as an FBI agent, but 10 years as a federal prosecutor before Attorney General Barr tasked him to review this case. It cannot go on any longer. This is the quintessential case for mandamus because we have both issues of judicial usurpation of executive prerogatives and a clear abuse of discretion. The judge has no authority to do anything further in the case. There's no case or controversy any longer. The parties have decided, the government has quit, and he also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons behind the executive's determination. The government has quit to dismiss the case. He also has no authority to go into the reasons.
Sorry, guys, we're trying to get this on here. It is a little bit of a mess up here. Stand by 1 second.
To the facts of Rinaldi. And in Fokker Services, this court issued the mandamus, of course, to proceed to make sure the deferred prosecution agreement was entered. And in doing so, it said the leave of court authority gives no power to the district court to deny a prosecutor's Rule 48A motion to dismiss charges based on disagreement with the prosecutor's exercise of charging authority.
For instance, let's suppose the district court had issued a minute order saying that it intends to do an independent evaluation of the record and will issue an opinion on the government's 48A motion in due course. Is that error?
I think that is error. I mean, he can look at it on the face of the documents that have been filed, but I don't think in Rinaldi that they went farther than the government's statements of what it was doing and why it was doing it. Only the executive can weigh the willingness of the government to prosecute, and there would be no remedy. I mean, the court can't make the government prosecute this case.
Well, in Thompson, another Supreme Court case that was cited by at least the government in their briefing, I can't remember if you cited it in yours also, the Supreme Court was reviewing a denial of a Rule 48A motion by the government, and it said that it performed, quote, an independent examination of the record, close quote. And that was despite the Solicitor General's suggestion that the court just simply dismiss the case. Do you disagree that that's what the court said that it did in Thompson?
No, but I think all that means is reviewing the documents that the government provided and the existing status of the record before it. not investigating new possibilities or assuming the role of the prosecutor to see about adding on perjury or contempt charges. He simply doesn't have the authority to do that. And without a case in controversy, he's without jurisdiction to do anything further. I mean,
well,
if we were here...
Your mandamus petition is the rulings under review are the failure of the court, the district court, to grant the motion. So you believe that just him not granting the motion is sufficient grounds in and of itself to justify mandamus, right?
Well, in Fokker, the court also said that the court's withholding of approval would amount to a substantial and unwarranted intrusion on the executive branch's fundamental prerogatives, and the judiciary's lack of competence to review the prosecution's initiation and dismissal of charges according to weight equally applies to the DPA decision. So either way,
so you believe that Fokker, a case that was not even a Rule 48A case, undermines what the Supreme Court did in Rinaldi and Thompson when the Supreme Court itself performed an independent evaluation of the record, when there was no argument there that there was any bad faith by the government or that the presumption of regularity didn't apply? You think that Fokker said that the Supreme Court got it wrong in Rinaldi and Thompson?
No, I'm saying that the independent review of the record consists of just that, a review of the record. And the record in this case is extremely well documented of prosecutorial misconduct and the suppression of Brady evidence that warrants dismissal under any circumstance, aside from the fact we have had motions to withdraw pending that were very well documented. I mean, this record contains enormous evidence now of government misconduct and the suppression of Brady evidence. It's just that the judge he doesn't have the authority to appoint an amicus under the Smith case that Justice Ginsburg just wrote the unanimous decision for. He can't go out and create new issues. Of course, he can look at the materials before him, and we welcome him doing that. But to go ahead and grant the motion, because there's no other alternative, not a single case in the country has ever affirmed the denial of a motion to dismiss under 48A.
Then it seems like you got a pretty good argument that you have an alternative avenue of review. Then if he denies the motion, then you can come back here on appeal, and you can cite all of those precedents to our court, and we can decide that issue at that time.
But he doesn't have the authority now to go beyond the record and do anything except that. We would simply be delaying the inevitable and going through an inordinate process in the process of doing that. I mean, we just got dumped on a 72-page brief that we have to answer by Wednesday with 500 pages of exhibits. Everybody else in this case is being paid by the government except my client's defense team. The toll it takes on a defendant to go through this is absolutely enormous, and it's not justified by this case. This is the most impressive motion to dismiss I've ever seen in decades of practice, and the most well-documented. In fact, in Judge Leon, I think it was a 2-page motion to dismiss, pursuant to which he dismissed 3 defendants for the government after guilty pleas just a couple of years ago. And, of course, in the United States, the government dismissed, and Judge Posner wrote that decision explaining how the special prosecutor's position had to be vacated and the motion to dismiss had to be granted on mandamus.
Let me ask you, this is Judge Henderson. If Judge Sullivan had just kept this motion waiting and languishing, it'd be one thing. He has set a hearing for mid-July. For all we know, by the end of July, he will have granted the motion.
But he doesn't have the authority to conduct that hearing, Your Honor. He has appointed this amicus to go far beyond the scope of his authority as a member of the judicial branch into the prerogatives of the Department of Justice.
I realize that, but you also know that the courts have said he's not merely a rubber stamp either. So there's nothing wrong with him holding a hearing as far as I know. I don't know of any authority that says he can't hold a hearing before he takes action.
Well, the only authority that, in their best case is in Ray Richards, in which the Third Circuit, on a motion to dismiss a sexual misconduct claim against someone in the Virgin Islands in a territorial court, said we got to have a little sunlight on the reasons here, because the only reason given was in the interest of justice. And certainly that's not sufficient. But even that case, it was actually altered by the court's decision or discussed by the court's decision in HSBC Bank, the case out of Mr. Gleason's court that reversed his overreaching authority on reviewing a 48A dismissal. And that HSBC case describes Richards as requiring a 48A dismissal because the district court's authority severely cabined the review to clearly contrary to the public interest, meaning the prosecutor acting in bad faith, such as bribery, fecklessness, animus to the victim, or his own self-interest, things like that. And there is none of that here. If Judge Sullivan had denied the motion to dismiss on this record, we would be entitled to mandamus right now. To drag this out another 6 months, I mean, it won't just be a hearing on July 16th. It'll go beyond that. I think it's clear from the amicus position now that they want to take General Flynn to sentencing as soon as possible and impose upon him the maximum possible sentence. And to make us go through that process when the ultimate result has to be the grant of the motion to dismiss, the government's just wasting resources out the wazoo pursuing this. And the toll it's taking on the defendant is certainly irreparable harm.
I'd like to ask you... go ahead.
Let me ask one last question, and that's, why couldn't we hold this in abeyance and let's see what happens on July 16th?
Because the damage continues to accrue by the day, because he has no case or controversy before him and no jurisdiction, because he doesn't have the authority to go do what he's trying to do or has done. He didn't even have the authority to appoint the amicus under Justice Ginsburg's decision.
I don't understand that argument. I mean, suppose in a run-of-the-mill criminal case, well, it's not run-of-the-mill because the government has evidence from a drone camera that was positioned to look through upstairs bedroom windows into the defendant's home, and the defendant moves to suppress, and amici, including the Cato Institute and other organizations, seek to participate as friends of the court in support of that motion to dismiss. You're saying that a district court wouldn't have authority to grant those motions?
No, I'm saying that he doesn't have authority to appoint an amicus to do the job that the government would have done if the government chose to continue the prosecution.
So the court can appoint amicus on the motion, but the court can't do it on its own motion?
No, I'm saying that the court cannot substitute its role for that of the government. It can't take the place of the Attorney General or appoint someone to take the place of the Attorney General. That's precisely what Judge Posner rejected in Ray United States. He can't go outside his lane to appoint somebody to do the job that
the order appointing amicus appointed him to present arguments in opposition to the government's motion to dismiss. That's all that it says in that paragraph. So how is that violating Article 2 to appoint someone to present arguments in opposition?
Because the government had already made the decision to stop, and the government is the only entity that can make that decision. The Department of Justice is the only entity that can decide whether to pursue this prosecution. The judge has no way of doing that on his own through amicus or a special prosecutor or anything else. The government has quit, and it's time to leave the field.
Ms. Powell, what about, sorry.
Go ahead.
What about, this is Judge Rao, what about appointing amicus for the contempt charges, right? I mean, the Supreme Court in the Young case said that the court can appoint a private party to prosecute contempt charges. I mean, do your arguments with respect to the appointment of the amicus apply also to the contempt charges?
Yes, as our amici pointed out, and we did also in our brief, contempt doesn't lie for perjury in these circumstances. There are 500 people in the national database of registry of exonerations who would otherwise be susceptible to perjury prosecutions because they entered guilty pleas, but they were actually innocent.
But Ms. Hall, that goes to the merits about whether contempt could actually be found. But what about the appointment of the amicus to look into contempt charges?
There's no basis to do that either. He doesn't have the authority to prosecute anyone for contempt. That's not the judge's place to add on charges. That is solely within the prerogatives of the Department of Justice.
But isn't that inconsistent with the Supreme Court decision in Young?
I don't see that inconsistency.
Well, in Young, the court said that the district court can appoint a private party to prosecute contempt charges.
Well, in the circumstances of this case, contempt cannot lie by virtue of him having moved to withdraw his guilty plea.
Well, let me ask you one other question about the contempt charges. I mean, if we decide that reassignment here is not appropriate, would we have any grounds for reaching the contempt question? I don't believe Mr. Flynn's petition for writ of mandamus asked for mandamus on the contempt question itself. Is there any grounds we would have for being able to reach that question?
Well, simply the fact that the judge doesn't have the authority to do it and there's no continuing case or controversy.
Can I ask a question about the continuing case or controversy point? In Thompson, the 1980 Supreme Court case that I referred to earlier that was cited in the briefs, the Supreme Court, the Solicitor General suggested to the Supreme Court that the case be dismissed under Rule 48A. And the Supreme Court did not itself dismiss the case, and the Supreme Court did not declare that there was no longer a case or controversy. Instead, the Supreme Court remanded the case to the Court of Appeals for reconsideration in light of the government's present position. So, in that case, the Supreme Court did not treat the fact that the government had filed a Rule 48A motion as ending the case so that there was no longer a case or controversy. Don't you agree?
Well, if I recall that case correctly, it was a mandamus for a mandamus. And what the Supreme Court decided was that the appellate court needed to address an additional issue. That is not our situation. With the fact that not a single court in the country has ever refused to affirm a 48A motion, there's no basis to proceed with this case. The government is the only entity, the Department of Justice is the only entity under Article 2, Section 3 that can prosecute the case. And they have decided not to do this for a number of reasons, not the least of which is the appalling suppression of exculpatory evidence that's gone on for as long as 3 years, the fact that the FBI agents literally made up statements to put in a 302, the fact that or Mr. Priestap had a discussion with Andrew McCabe about trying to get the defendant to lie and, what is our goal here, and came back the next day reconsidering the fact that they had decided not to show him the evidence that they had like they do with everybody else, the fact they decided not to even give him a 1001 mention, not even a warning, of course, no warning, but not even to mention 1001. They sent agents over there, according to Mr. Comey's testimony, just told him a couple of agents were going to drop by. Was that okay? And he said, of course, sure. He works with them all the time. I mean, this is an appalling injustice. It's a travesty of justice that this man has been dragged through this for 3 years on a case that was absolutely concocted by FBI agents with some help from the Department of Justice, and evidence falsified and everything else. The government has provided extraordinary documentation, and the only thing left to do is for the judge to order the dismissal of this case. The delay—
You can't do an independent evaluation of the record before entering that dismissal.
No, he can look at the record. He can look at the record, but the only thing to do as a result of that is to order this dismissal because of the presumption of regularity that attaches and the fact there's no clear evidence of anything else. He can't make up these things he calls reasonable, plausible questions that don't even relate to the motion to dismiss and proceed to drag this out forever. It's just not— I mean, it's contradictory to Fokker Services. It's contradictory to Rinaldi. It's contradictory to the NRA United States and the Fourth Circuit in Smith and the Fifth Circuit in Ham.
Where in the orders under review did the district court say anything about reasonable, plausible questions?
It's in their brief.
That's not the order under review, though. The order under review is, from your perspective, is him not granting the motion. That not granting the motion itself is grounds for mandamus.
And appointing the amicus to do anything. But
so,
yes.
So we have to find both of those things to be improper to justify amicus. Is that your position, or is one of them, any one of them by itself, grounds for mandamus?
I think either one by itself is grounds for mandamus. They're independent grounds for mandamus.
Ms. Powell, let me ask you something about this appointment of amicus. In Fokker Services, we ourselves appointed amicus. Now, if Judge Sullivan had not appointed amicus, would you be telling us that we couldn't appoint amicus?
No, ma'am. You can appoint amicus to weigh in on any issue the Court of Appeals wants an amicus to weigh in on, as long as it's an issue within the case and the Court of Appeals didn't create it. What Judge Sullivan has done here is created his own issues that he wants to investigate that aren't related to the motion to dismiss or even the case before him in any way. He wants to add on charges that he can't.
But in Fokker Services, we appointed someone to defend Judge Leon's order. And this is what Judge Sullivan—
that's what Ms. Wilkinson is doing here before this court. She's the analogous piece of that proposition, not Mr. Gleason.
That's true. And you have no problem with her, obviously.
No, obviously she's entitled to be here on behalf of the judge. Appellate courts often allow amicus participation, but the district court doesn't in criminal cases. There's not even a provision in the rule for that. In fact, if you go try to file a brief as an amicus in the district court, you can't do it properly. All the docket entries had to be corrected. There's no provision for amicus in criminal cases.
So I asked you earlier if an amicus could file a motion in support, a brief in support of a motion to suppress. What's your answer? Is there authority for that, yes or no?
I would think there's authority for that.
Based
in
on
support
what?
of a motion that another party has filed. If the judge wants to allow it, it would require leave of court, I would think.
Based on what rule?
I don't think there's a rule for it, but I do believe that, for instance, there have been amici in other cases in the district court level, but it's been in support of a position of one of the parties, not in support of a judge trying to gin up additional charges himself.
Well, just with respect to the Rule 48A motion, it's your contention that if for some reason Mr. Flynn opposed the government's motion, it would be okay for an amicus to enter an appearance to file briefs in support of Mr. Flynn, right?
Well, at least there would still be a case in controversy before the court, and it would be up to the district court whether to allow leave to do that. I don't see a provision in the rules for it, but generally speaking, district courts I've known kind of do what they want to do within bounds of reason.
So there's authority for it so long as there's a case or controversy? Is that, I'm just trying to understand your legal reasoning here.
The legal reasoning is that he essentially appointed Mr. Gleason as a special prosecutor, that he doesn't have the authority to do. If he'd asked Mr. Gleason, for example, to weigh in on a side that existed in the case, that might be permissible. I would probably still argue against it, but I wouldn't have sought a writ of mandamus on it, I don't think. But to bring in...
Isn't your argument also that it's impermissible to have amicus briefs in criminal cases under the rules of the court?
Yes, that is one of our arguments here, because there is no rule providing for it. But like I said, I've certainly seen it done in other districts' courts as long as it's on the side of one of the parties that seeks to continue the litigation, just not on behalf of the judge as an independent prosecutor himself.
All right. Are there any more questions? Okay. Ms. Powell, we'll give you a couple minutes in reply. Next is Mr. Wall.
Thank you, Your Honor. And may it please the Court, Jeff Wall for the United States. I'd like to, I hope I'll have the opportunity to address a number of the questions that the Court has asked Petitioner's counsel, but I want to start with 2 points. One on the merits to you, Judge Wilkins, and one on harms to you, Judge Henderson. And I think, by the way, that's the right order to take them. In recent mandamus cases like Fokker and like Blumenthal, the Emoluments Clause case, the Court looked at the merits, asked whether there was a clear and indisputable right on the merits, and then turned to the mandamus factors and the harms. I think that makes particular sense here, because if we're clearly right about Fokker, that it doesn't leave an oversight power in the courts or a substantial role with respect to unopposed Rule 48 motions, then I think it's easier to see, Judge Henderson, why it's so harmful to continue to allow this process to play itself out in the district court. Taking the merits first, Judge Wilkins, Rinaldi was a case in which the Court assumed, and I think it's clearest in footnote 15, it assumed the broader standard and then said even that standard can't be satisfied, so the trial court has abused its discretion in denying a motion. A motion, by the way, that came after judgment in that case, not just after a plea or a trial, but after judgment. And Thompson, of course, was just a case in which we wanted to pull the prosecution in the Supreme Court, and we asked the court to GVR. And even there, after an affirmance in the Court of Appeals, it sent it back to the district court to allow us to do that. But I completely grant, Judge Wilkins, neither one of those cases resolves the substantive standard for Rule 48. They resolve that Rule 48 applies, contra respondent's assertion, all the way on direct review. There's no magical line at the plea. But they don't resolve the substantive standard. The case that does that, and the case that we rely on for mandamus here, is this Court's decision in Fokker. That's the decision that resolves the substantive standard for the denial of a Rule 48 motion.
How does it resolve that when the case was not an appeal of a Rule 48A motion?
Because what Chief Judge Srinivasan did in discussing the DPA was he explained how DPAs and Rule 48 motions are analogous, and he separated off approval of a plea agreement under Rule 11. And that analogy was central to the court's reasoning, right? In order for the court to say that district court erred in a way that justified mandamus, he said the error is so clear because look at what has to be the rule under Rule 48, and then that has to be the rule for DPAs as well. So I understand parts 2A and 2B of the opinion in Fokker to be central to the judgment and to what it goes on to do when it applies that standard later in the opinion. And I think the language of Fokker, when it goes through that discussion, leaves no doubt. It says dismissing charges, not just commencing, but dismissing, is squarely within the can of prosecutorial discretion. It says there's no oversight power in the courts, no involvement by the judiciary, and it says no substantial role for courts. And if we're right about what Fokker says with respect to Rule 48, then to turn to my point to you, Judge Henderson, then it's really a question of what are the point of further proceedings if the district court is required by circuit case law to grant the Rule 48 motion. And
you believe that Fokker stands for the proposition that the district court can't perform an independent evaluation of the record?
I think it does in the following sense, Judge Wilkins. I understand Fokker to mean that if tomorrow, faced with the kind of tolling agreement that was at issue in Fokker, a district court said, I'm going to set up a process for deciding whether to grant this agreement. I'll hear from both sides. There are a number of factual questions I'm going to have to resolve about whether you've gone too easy on particular defendants. And the district court did all of that. I understand that to be, yes, a straightforward violation of Fokker. And again, it's not just the sort of idea that there will be some briefs and a hearing, Judge Henderson. The harm is that, as the respondent explains, both in the opening brief and page 2 of the reply, the point of this is to investigate, they say, the prosecutorial decisions and prosecutorial motives. Those are respondents' words.
The order itself says that which is under review says that amicus is appointed to present arguments in opposition to the government's motion to dismiss. That's the order under review. So it doesn't say anything about, fact development or anything else.
So with all respect, Judge Wilkins, 2 points. First, we're not here on appeal from an order. We are here, as you know, on mandamus, and mandamus is an extraordinary writ that directs the district court to do something. It's not necessarily a review of an order. And here we're asking that the district court be directed to grant the Rule 48 motion. But second, beyond the order, the reason for entering the order, as respondents' briefs in this court have explained, so we now know what's going to go on below. Respondent wants to inquire into what they say are prosecutorial decisions and prosecutorial motives, because the district court is concerned that there was improper influence here, and indeed both the district court and the court-appointed amicus have, on the one hand, suggested, and with respect to the amicus, flat out alleged that there was misconduct on the part of the Attorney General and even the President of the United States. That's going to mean that we are, in the district court's view, going to have to come in and answer those questions and defend against them. And that's all of the systemic costs that this court laid out in Part 2A of Fokker. So in order to have the sort of anodyne proceeding that some of these questions are assuming, this court would have to issue mandamus. You'd have to take off the table evidentiary proceedings and the like. You'd have to take off the table contempt. You'd have to say just the Rule 48 motion, you address that with dispatch, and then you could come back to this court. But at that point, if that's the proceeding, there's
the district court doesn't even have the authority to appoint amicus to advise it on whether it should issue an order to show cause for contempt.
So, Judge Wilkins, we, unlike the petitioner, we have not argued that district court generally lacks the power to appoint amici, I think, either under the rules or more likely under their inherent authority. But what we have said is that the particular amicus here is improper for all the same reasons that appointing amici and going through an elaborate process would be improper in the DPA context under Fokker. And if that's true, then a fortiori it's got to be true for the Rule 48 context, which was the basis for Fokker's reasoning with respect to DPAs. So we're not saying that the district courts don't have the power to do this generally. What we're saying is that here that there are problems with this particular appointment of the amicus. And just to get back to your question, Judge Henderson, I think once we know that those are the harms, there's no reason not to take that final step, because we know the harms that are going to play out. This has already become, and I think is only becoming more of, a public spectacle, particularly in light of the amicus filing in the district court 2 days ago. And it threatens to harm not just the integrity of the executive and its prosecutorial discretion and its deliberative processes, but I think, frankly, it threatens to do harm to the judiciary as well.
Mr. Wall, if I could just ask you, I mean, the court has, our court has repeatedly declined to grant mandamus when the government addresses abstract separation of powers violations, such as in al-Nashiri. So I'm just wondering if you can be more specific and more particular about what the concrete separation of powers violation is here. Rule 48 does allow leave of court, right? So is the problem, what precisely is the problem here? What precisely is the infringement on the Article 2 power?
I think, Judge Rao, that the separation of powers harms here, you're right, they can be very subtle and very abstract in a lot of cases. I think they are as stark and as concrete here as they come. Because here we know from what's transpired below and from the briefs in this court that what the district court is contemplating is a sort of intrusive, fact-intensive inquiry into what they say are a host of factual questions. Why did particular prosecutors not sign the brief? Why did the Attorney General make this decision? Was he right on these various grounds? What about the uncharged conduct with respect to the Turkey statements? We're going to have to brief and apparently put on evidence in defense of all of that so that the district court can then reach a decision when circuit law compels him to grant the motion. And I think it is an intrusive process, and it is going to harm the executive, and we can't ignore that it is playing out in a politicized environment that I think is made worse by the kind of, honestly, the sort of 70-page almost polemic that the court-appointed amicus filed, which alleges that the president and the attorney general have engaged in grave misconduct. So when you're looking at those kinds of allegations, you're forcing us to defend against them, all in a context where this court's case law says that's exactly what courts shouldn't be doing. It says, quote, no substantial role, end quote. It's hard for me to see a much clearer.
But the court, but all of the 48A opinions from every court has said that the court has some role in that. The role involves making sure that there's not something that's being done clearly contrary to the public interest. So then there must be some case where or some set of circumstances where, as unfortunate as the clash of the two branches of government might be, where Rule 48A does some work. Isn't that right?
Judge Wilkes, I think it is right in the following sense. 48A does work in cases where it's an opposed motion. And even where it's an unopposed motion, we don't dispute that the court can ascertain that it's got the considered decisions of the parties. You don't have a prosecutor who's been bribed or a defendant who hasn't been counseled about the dismissal. But we do say that for unopposed motions to dismiss, relatively small set of applications under 48A, that where the parties agree and they are both making considered decisions, yes, the court is required to grant in light of the constitutional concerns that this court discussed in Fokker. And the second thing I'd say, Judge Wilkins, just to drive this home is, I understand respondent to accept that everything I just said is right in the pre-plea situation. They agree that if the defendant hadn't pleaded and this was just an ongoing prosecution, we could pull this back. There'd be nothing a court could do about it, couldn't force us to go to trial. And a court, even if it were upset about our motives, couldn't perform any oversight. It would need to grant the motion. And so the move that they make, and it's the key to the merits at page 19 of the reply, is to say, okay, but Fokker is just for the pre-plea situation. It doesn't apply once the court has accepted the plea. And I think that's got to be wrong for no fewer than four reasons. First, once we know that it's not the concern of the rule in most of the cases, which are the pre-plea cases, then we know it's not really what the rule cares about. Second, the constitutional concerns are exactly the same after the plea. We no longer want to proceed as the executive, and there's no longer a controversy between the parties. Third, we know, as you said from Rinaldi, the U.S. can dismiss even after judgment, even after trial, let alone after a plea. So there's no magical plea line. And fourth, Fokker rejected exactly this distinction. It said accepting the plea agreement, to be sure, is a judicial act. That calls on the court's authority. But just dismissing, that it said doesn't. That's just letting a case go in deference to the executive's exercise of prosecutorial discretion. And once you know that that plea line, there's nothing magical about that in terms of Rule 48 or the Constitution, then I think their case on the merits collapses, and then we're just back to Judge Henderson's question about the harms and why grant mandamus now.
But Fokker made clear that there are different considerations at different stages of a criminal case, to the extent that you, even if we credit that Fokker is binding on Rule 48A, in here we have two different district judges that, as a part of their obligations under Rule 11, made factual findings as to materiality and a basis for a plea, etc. And so the government's motion doesn't just implicate the government's position, it implicates those rulings that two district court judges have made. So the case isn't in the same posture as it would be prior to a plea agreement in that respect.
Well, I absolutely agree with part of that, Judge Wilkins. It is certainly true that there are different concerns at different stages, and Fokker says accepting the plea agreement does call on the court's authority because it has to ascertain whether there's a factual basis for the plea, but it contrasts that with dismissal. And take a case like, and so the part I disagree with is that once you've crossed that plea line and a defendant has pleaded, that suddenly everything that follows invokes the court's authority in some way that changes the calculus, because Fokker says that's not true. And the best example, I think, is in the United States in the Seventh Circuit. The district court, there wasn't just a plea, there was a sentence. And in light of the sentence, the government wanted to dismiss some of the charges because it no longer wanted to proceed with them. And the district court was upset about that. It wouldn't allow the government to dismiss. And the Seventh Circuit said, look, it doesn't matter, even if the government's trying to get around the district court's sentencing authority. It's the master of its own case. It gets to decide when to bring or when to dismiss charges. So I agree that of Rule 11 acceptance of a plea agreement, if that's what were before the court, that's different. But this, and Fokker's language is crystal clear about this, it says accepting DPAs and dismissing under Rule 48, it says, quote, are not formal judicial action imposing or adopting, end quote, terms on defendants or parties. They're not the court formally signing off on anything. When Judge Sullivan grants this Rule 48 motion, as he's required to, he's not taking back anything he's done before. He's not expressing any opinion on the government's case. He's not saying he agrees or disagrees. He's just acknowledging a co-equal branches exercise of its core executive power.
I have a question about your position, the United States position about its representations in support of a Rule 48A motion. Is it your position that the government does not have to state all of its reasons in support of dismissing the case, only those that it chooses to share with the court?
It is, Judge Wilkins, but I don't think anything turns on that here and that you need to agree with me on that. I think we could have come in and just moved to dismiss without providing an explanation to the district court. We do that at times, and district courts routinely grant them. No appellate courts ever reversed in a situation like that. But here we did. We went beyond what we thought we were obligated to do under the circumstances. We provided a robust explanation to the district court, and we think whatever Rule 48 might require as a procedural matter, we've more than cleared that hurdle, as Ms. Powell said. I mean, I think this is one of the most robust Rule 48 motions you'll find.
So to, I guess, understand my concern, suppose you have a case where a federal law enforcement officer has pleaded guilty to a criminal civil rights violation for using excessive force. And then the government says that they've uncovered some Brady evidence and are moving to dismiss under 48A after the guilty plea. But part of the reasoning of the authorities was that as to why they didn't believe they'd be able to prove this case beyond a reasonable doubt was that the defendant is black. I'm sorry, the victim is black. The defendant, law enforcement officer, is white, and they did not believe that the jury would believe the black victim over the white officer without corroborating evidence. And that's unfortunate, but that's the reality. And so that was one of their reasons for dismissing. But they thought that that wouldn't play well, so they didn't say that in the motion. They just said that the exculpatory evidence was the reason they're dismissing. Is that proper?
So 2 points, Judge Wilkins. One is legal and one is practical. The legal one is that there's an easy way to deal with that here given the mandamus posture. I think Fokker is clear that the government, as long as it provides no reason or any reason at all, can and it's not an unconstitutional reason, can dismiss. So yes, I think that motion there should be granted. But the easy way to deal with that in the mandamus posture is to say, look, even if you think that there's room for some kind of a Richards-like rule, or we think there's it's not clear and indisputable.
I'm sorry, I couldn't hear about 10 seconds of that. Could you repeat whatever you said?
Sure, I'm sorry, Judge Wilkins. If you thought that it wasn't clear under Fokker whether the court could allow that type of explanation, you could try to leave that open and just say, look, whatever that might be on the merits, it's clear and indisputable that wherever the bar is, the government met it here through its fairly fulsome explanation. And the practical thing I'd say is, I certainly hope that the government hasn't ever filed a motion like that, and I'm not aware of it. But even then, yes, I think the court should have to grant it because the government, whatever its motive, no longer wants to proceed. But what you would see is you'd see other defendants walking in, attaching that motion, and bringing Armstrong claims, saying the government is making racially based decisions in its prosecutions. And based on your hypo, it sounds like they'd have pretty good grounds for that. So I think there are remedies for this other than needing to contort Rule 48 to get into what the executive's motives are. If there's remedies for it, there can't be a remedy for it unless you know that it's happening. And if the government doesn't have to disclose all of its reasons, then you never know that it's happening, right? But that's always...
And if the district court isn't allowed to ask whether there were any other reasons, you'd never know that it's happening, right?
But that would be equally true in a case like Fokker, Judge Wilkins. I mean, the district court could always say, look, I think that the U.S. attorney has cut a sweetheart deal with the corporate defendants here. And so I want to get some briefing and I want some argument and hearing on whether there was improper influence brought to bear on this. And the point of Fokker is that it isn't to the courts to police whether the executive has pure or impure motives. The remedies for those occur in political and public arenas. Retaliation from the other branches, dismissal of corrupt executive officials, even impeachment if it comes to it. But Rule 48, Fokker says, is not the mechanism for policing the kind of harms that you're worried about. And if a court could do the sort of thing you're talking about, then I think Fokker has to be a dead letter. Because either with respect to Rule 48 or a DPA, a court concerned about the executive's motives could always inquire. And I understand that inquiry to be exactly what Fokker shuts off.
So, Mr. Wall, are you suggesting, normally the standard is that there is a presumption of regularity. What about the case in which a district court feels that that presumption is overcome on the face of the materials presented by the government?
So 2 points, Judge Rao. First, I don't think that presumption is relevant here, and put it to you this way. If a district court thought that the government had a bad faith motive for declining to bring a prosecution, I take it everyone agrees that the court couldn't force the U.S. to bring the case. And the same is true for maintaining a prosecution. As Fokker says, there's no oversight role for the courts. And when it refers, this is the key thing, Judge Rao, when it refers to the presumption of regularity, it's not saying there's some exception to the rule it's laying down in that situation. If you look at that passage of the opinion, all it's doing is listing that as another reason for adopting its rule. which is that even with respect to constitutional claims, the courts are very loath to second guess in the absence of clear evidence of a unconstitutional motive. And so it gives that as a reason for reading Rule 48 its way. It's not adopting some exception to its reading of the rule. But even if it were, we'd still be entitled to mandamus, because Armstrong is completely clear, Judge Rod, that you have to have clear evidence of an unconstitutional motive to rebut the presumption. And they can argue back and forth about whether they think the Attorney General is right about this or about that. But there's nothing here that remotely approaches clear evidence of an unconstitutional motive. That's what you need to rebut the presumption, even if it were relevant.
So irregularity, in your view, would only be an impermissible motive? There are not other types of irregularities?
That's right, because it's only an unconstitutional motive that would allow the court to step in, that you need an independent constitutional limit, like a racially based prosecution. So yes, if a district court thought that a U.S. attorney were favoring his friend, that would be terrible conduct. There are political remedies for that, but there aren't judicial remedies under Rule 48. If the considered decision of the executive branch, whatever its motives, is that it no longer wishes to proceed, it doesn't have to bring the case. And by the way, whatever its motives, there's no longer an Article 3 case or controversy. There's
so even if the prosecutor was dismissing the case because it did not believe that a white police officer should have to answer for using excessive force on a black defendant, and they say that in their pleading under Rule 48A, the district court still has to grant the motion.
Judge Wilkins, I don't think that the court can force the executive to keep that case alive in the absence of a case or controversy. As I tried to say earlier, it may well be a basis for dismissing other prosecutions. But even if you disagree with me on that, the reason your hypothetical has force is because it's an unconstitutional motive. It's the kind of thing that could qualify for Armstrong. And you can bracket that question off if you think that soccer isn't as categorical as I do, because there's nothing like that here. And I don't think you can leverage that, Judge Wilkins, to say, well, if we can inquire on when we've got...
Then what does leave of court mean, then? What work at all does leave of court do, then?
Well, it does work, of course, with respect to opposed motions to dismiss, and the work that it does for the far smaller set of unopposed motions in a situation like this is it allows the court to make sure that it's the considered decision of the executive, you don't have a prosecutor who's been bribed, and it's the considered position of the defendant. The defendant hasn't been poorly counseled. Imagine a situation where a defendant agrees to a dismissal without prejudice, even when the government has repeatedly been bringing charges and then dismissing them on the eve of trial. I think certainly a district court is warranted in asking the defendant, are you sure about this? Because it sure seems like the government keeps yanking your chain.
So why isn't it the case that if the government makes a considered but racist decision, that it just does not want to have a white officer stand trial for excessive force on a black victim, that the district court can deny the motion, and then the political chips can fall where they may, and perhaps under pressure from the public or Congress or whatever, the district court may not be able itself to force the government to prosecute the case, but maybe through the operation of the legislative branch or other pressures from the public and the media, a new prosecutor is appointed and the case proceeds. Why isn't that exactly what leave of court should operate to do?
So, Judge Wilkins, your question, I think, recognizes the answer, which is, as you say, there's no power to make the executive move forward to trial, which I think goes to show why this isn't the concern of Rule 48. But if the government can't make the case go away and the case is in limbo, then while it's in limbo, pressure could be brought to bear on the government to reconsider its decision, right? Let me say two more things, Judge Wilkins. First, I think, as Judge Kavanaugh explained in Aiken, the remedy for that kind of an equal protection violation is to dismiss other cases. It's not to compel the government to move forward with this prosecution. Second, even if you disagree with the reasoning of Aiken, if you had that kind of a case where the prosecutor put forward on its face in the motion evidence, clear evidence under Armstrong of an unconstitutional motive, I think you could bracket off that case. And as a constitutional matter, we don't have anything like that here. And just to square the circle, you can't leverage that back, I think, to saying that even if you could inquire in some Armstrong-type case because the face of the motion disclosed a possible constitutional violation, that then you can inquire in every case. That then would just eat the rule. So I think Aiken is right that there are other remedies for the equal protection violation. It's not meant to be taken care of under Rule 48, but you don't have to agree with me on that, because here, no one, I think, is arguing, not even a respondent, that on the face of the motion to dismiss that the government filed, there's any unconstitutionality, there's any evidence that we violated the Equal Protection Clause or anything like that.
Thank you.
Mr. Wall, let me ask you, you threw out a question probably 30 minutes ago. What would be the harm in going ahead and mandating the granting of the motion to dismiss? The harm is, to me anyway, regular order. And mandamus is a drastic remedy. You know that. We all know that. Nobody's been able to find a case in which mandamus has issued where the district court has not acted in the sense of a ruling, an order, something that we can review. Now, this district judge has taken two actions. He's appointed an amicus and he's set a hearing. Now, unless you agree with Ms. Powell that the setting of a hearing is something that's ultra vires, that leaves the appointment of the amicus. And granted, he may have chosen an intemperate amicus, but that doesn't mean that he is going to deny this motion. And considering the drastic remedy that mandamus is, considering there's no precedent that allows us to move without an order, I don't see, and considering that there's a hearing been set for July 16th, I don't see why we don't observe regular order and allow him to rule. For all we know, he will say this amicus brief is over the top, the dismissal motion is granted.
So, Judge Henderson, a few points. Yes, it's an extraordinary writ. We would say this is an extraordinary case. I think we're well past regular order.
I agree with that. I agree it's an extraordinary case.
And I think, if I would say, like, at a minimum, in order to have the sort of regular order you're talking about, the court should still issue a more limited form of mandamus that takes off the table these evidentiary questions. They want to probe the executive's motives, and we'll have to defend against that. They say in their brief, quote, affidavits and declarations, end quote. And it seems to me that they want some evidentiary or discovery process. I think that clearly should be off the table, and contempt should be off the table. If all we're talking about is the meaning of Fokker and Rule 48, and the court's going to decide that at the hearing with dispatch, we can come right back to the circuit. I think at a minimum you need that in order to get the sort of regular order you're talking about. But then I would say, Judge Henderson, and the reason I think you should go a step further is it's just not true that even if, as limited, he just denies or he grants the Rule 48 motion, it's still not the case that the parties haven't suffered harms. The harms to General Flynn are obvious from the continued prosecution and the threat of contempt, unless this court takes it away. But the harms to the government are really what I'm focused on. You have, as you say, a potentially intemperate amicus. You have all of these allegations being lobbied at the executive branch. We're going to have to answer them in a public forum in a politicized environment. That's exactly the sort of thing that Fokker, when it walks through the harms in Part 2A, says you shouldn't be doing. It invades our deliberative process. It chills law enforcement. It sets up a conflict between the branches. And so I agree with you.
But we don't We don't know that's going to happen. We have Judge Sullivan, who is an old hand. He's an excellent trial judge. And he may say to himself, at least, you know, I asked for advice, and I'm ignoring it, and I'm granting the motion to dismiss. Shouldn't he be allowed to do that?
I think Judge Henderson and the government respects Judge Sullivan, as you say, an experienced judge on the district court. I think because we are past regular order, we have crossed into the mandamus threshold. If we had gone about this a different way, I might agree with you that order ought to be maintained. But because we've reached a point where you have the district court in its brief raising questions about prosecutorial motives, if the court-appointed amicus driving that home in its brief, the court is apparently contemplating that we'll defend ourselves and lay out exactly why we've done what we've done. All of this playing out against the backdrop of these incredibly harmful allegations. And I think if it isn't already, it is threatening to become and will become the sort of public spectacle that I think mandamus is warranted to foreclose at this point. And I agree with you, Judge Henderson. I wish we weren't here, but we are. Fokker is clear about granting the Rule 48 motion, and so there isn't. It's why would we have these unnecessary proceedings when they are really going to do damage to the executive branch at this point, given the way they've set up and the environment they're playing out in?
But the government didn't file a petition for writ of mandamus. Mr. Flynn did.
So that's very fair, Judge Wilkins. I don't want to get too much into the government's deliberative process because, of course, our whole point is that's not permissible under Rule 48. But what I can say is there was uncertainty in the district court about what the district court was going to do. And on the same day the district court set the briefing schedule, before we'd made any final decision, General Flynn filed his mandamus petition. And at that point, we had to decide whether to support it or whether to file a duplicative petition that risked slowing this down. And we obviously decided to support the mandamus petition. And I think, honestly, it would be artificial to cabin off the separation of powers harms here just because we didn't file our own petition when, you know, they're presented in stark relief. And certainly if that were important to the court, it should at least give us the opportunity to file some short mandamus petition that could be consolidated with General Flynn's, because we are here saying there are serious, indeed grave, I think to Judge Rao's point, stark separation of powers concerns playing themselves out. These are not the sort of subtle abstract things that sometimes present themselves in these Article 2 and Article 3 cases. You have a court that is considering whether to keep alive a prosecution.
You're talking about regular order, and then you're saying that, well, we didn't file a mandamus petition, but if that's important, then give us leave here after argument to file one. I mean, that's far from regular order here. And you're arguing that, you know, if you're not inclined to grant the principal relief by the people who filed the motion, then grant some form of limited mandamus relief. And you're making that argument even though you don't have a mandamus petition before us. I mean, none of that is regular order, counsel.
Judge Wilkins, I'll grant that very little about this case is regular order at this point. I don't think that our not filing a mandamus petition should be taken as legally relevant in any way. We are a respondent supporting petitioner that regularly occurs in courts, including the Supreme Court. We make the full range of arguments, and our legal arguments and our harms are considered by those courts, as I think they should be here. And my only point to Judge Henderson was, to get us back to regular order, you'd need at least mandamus that would take off the table the evidentiary proceedings and questions and contempt. But even if you just narrowed it to the legal question of the meaning of Rule 48, which would mean that the vast bulk of the court-appointed amicus brief is no longer relevant to the hearing, even then, you still ought to take the additional step of granting mandamus. And the cases, Judge Henderson, I would point you to are Fokker and In re United States themselves. Those were questions of first impression, but both this court and the Seventh Circuit said the constitutional principles are so clear we're going to give mandamus. And here we have not just the constitutional concerns under Article 2 and Article 3, but you have the decision in Fokker itself. So I think the case for mandamus,
I keep coming back to in Fokker, the district, we knew what the district court did. We don't here.
Oh, I agree, and I think it's possible then that if you'd come up at an earlier stage in Fokker, this court wouldn't have granted mandamus. But once it grants mandamus in Fokker and explains why it's doing it, and it explains how it reads Rule 48, and it says a dozen different times that there's prosecutorial discretion, courts can't scrutinize, there's no oversight. It's not just impugning the decision of the district court there, it's impugning everything the district court was doing that led up to it, because courts, it says, don't have any substantial role. They have, quote, no oversight power, end quote. And so once you know that from Fokker, then I take the point that, look, this is not briefs and hearing. That's not what this is right now. That is not how this is shaping up in the district court. But even if we were somehow to limit it to a more normal type proceeding without all of the stuff that respondent and brief says it wants to get into, that's all now squarely foreclosed by Fokker. So I understand pre-Fokker why it might not have been enough, but it seems to be now it indisputably is.
Mr. Wall, I'm concerned about your fallback position that we could grant some kind of partial relief. I mean, wouldn't that require the court to articulate actually far more legal standards about what precisely is on and off the table? That seems to be a lot of law to be making in the mandamus posture, and seems much less clean than just, issuing a writ of mandamus in full. I'm just wondering if you really think that this partial mandamus would actually be more minimalist than a clean writ of mandamus.
No, Judge Rao, let me be very clear about this. The writ of mandamus is warranted here. It is clear and indisputable that the Rule 48 motion has to be granted under Rule 48, and if we're right about that, there is no reason to let these harmful proceedings play themselves out in the district court. So we completely agree that the cleanest way to resolve the case under Fokker is to grant the writ. I was just explaining to Judge Henderson that if the court sort of has these concerns about granting the writ, it seems a little bit unfair to the petitioner and the government to say you should observe regular order, because nothing about these proceedings threatens to be regular. To put them back on a regular track, you have to grant at least some kind of mandamus. But I completely agree with you that that does require you to say, look, Fokker is clear that it doesn't have evidence, and it does require you to address the contempt piece. The cleaner way to do it is just to say, Fokker is clear that the court has to grant the Rule 48 motion. And so, given the harms to the defendant and the government, the writ should issue. And I will fully grant Judge Henderson that it's an extraordinary writ, and we do not ask for it in ordinary cases, and in an ordinary dispute between private parties, it wouldn't be appropriate here. But this is a separation of powers case. I mean, if you take a case like Cheney, where you just think about discovery, bringing the branches into possible conflict, and the Supreme Court grants mandamus, this case, it seems to me, is two steps beyond that. You have actual conflict between the branches, where the court wants to inquire into why we did this in the face of allegations that there was some impropriety. And I understand that to be exactly what Chief Judge Srinivasan said in Fokker courts may not do. And I really don't think it's hard to see what the harms are going to be to the government over the next couple of months if we and the defendant are put through that process, which is all for naught, if at the end of the day the district court is required by law to grant our motion.
Well, let's drop the phrase regular order, and let's talk about one of the requirements I don't think I've heard anybody mention, and that is the adequate remedy at law. That's what I'm talking about as far as regular order. You granted, assuming you have an indisputable right, and that to me seems pretty clear. You still have to say why there is no adequate remedy at law. And I'm not going to repeat myself, but why is there none if on July 16th, Judge Sullivan grants the motion to dismiss?
So I'll I'll take one more stab, Judge Henderson, and I think it's this. Even if, a month or two from now, the court grants our Rule 48 motion, in the meantime, you will have a proceeding that's forcing us to explain ourselves, to do it apparently through affidavits, declarations, some kind of an evidentiary process in the district court. I don't know whether, the district court is very careful in its briefs not to say exactly what it envisions, but the district court has left itself room for not just documents of that kind, but witnesses and all the rest. And that is going to intrude, all the harms in Part 2A of FACR, it's going to intrude on our deliberative process. And I think the court has to take account of the fact that both respondents' briefs and the court-appointed amicus, they're impugning the motives of the Attorney General of the United States, and it's going to pull the judiciary into a fight that should play out in a public political arena. And I think those are real harms to the executive branch, even if at the end of having been put through that whole process and what I think threatens to be a spectacle in the district court ultimately grants the Rule 48 motion. And if we're right, as you started, that FACR says the district courts shouldn't be doing these things, it's hard to imagine a case where a district court would do something foreclosed by FACR that would be more harmful than what we're facing on the circumstances here. If ever the court were going to say a district court needs to grant the Rule 48 motion, that's what FACR clearly and indisputably requires. It seems like this would be the classic case.
All right. Are there any more questions?
No.
If not, then we'll hear from Ms. Wilkinson. Thank you, Mr. Wall.
Thank you, Judge Henderson, and may it please the court. The petition asks this court to grant really an extraordinary remedy for mandamus, to prevent this district court from even considering or questioning a pending motion. This court should deny that petition for three reasons. First, the government's motion, as this court has already pointed out, is still pending, and it may very well be granted. Alternative relief is available below. Second, the law does not clearly and indisputably foreclose the district court's consideration of the government's motion. And third, it would be inappropriate to grant mandamus in a case involving open questions where the government is raising novel constitutional arguments that were not raised below. As this court has said, it is essential for those questions to be raised below to maintain the regular order. No one disputes that a federal district court cannot second-guess a legitimate exercise of prosecutorial discretion simply because it disagrees with it. But that is not the issue before the court. The issue here is whether a federal district court judge can set an expedited briefing schedule and appoint an amicus to provide adversarial briefing before ruling on a motion that requires leave of court. The answer is and must be yes. Judge DeSelve, yes, Judge Rao.
Ms. Wilkinson, yes. So, but I mean, in a case such as this, where both the government and the defendant agree with the motion to dismiss, I mean, isn't the appointment of an amicus creating an Article III case or controversy where there isn't one?
No, Your Honor, there is a case in controversy here for several reasons. One, as you know, the government and the defendant are asking for the motion to be dismissed with prejudice. By definition, there cannot be a ruling to dismiss those charges with prejudice if the court doesn't have jurisdiction. And the parties want that, of course, because they don't want another prosecutor to come back and then look at these charges and bring those charges against Mr. Flynn. So everyone in this case agrees that this motion, if it should be granted with prejudice, so the charges are ended.
Well, what happens, though, in a case, maybe another way of asking this, if the district court were to determine that the motion to dismiss should be denied, then what happens? Then we go on to sentencing Mr. Flynn, even though the executive is no longer pressing its prosecution.
There's no reason at this point to fear that the district court is going to deny the government's motion to dismiss. But if for some reason the facts or the answers to the questions at the hearing gave some basis for that, I'm sure the parties, including the government this time, and Mr. Flynn, would file another motion or another writ for mandamus. And that happened in Ray Aikens, as you know, and there the court said and denied the first motion or the writ because they said the government hadn't had the chance to act. And in fact, they gave years to the government agency, the NRC, to make that decision. And only when that agency announced that it would not rule did this court issue a writ of mandamus. So here we're not in any situation similar to that. As Judge Henderson has said, the court only set a briefing schedule and has a hearing for July 16th. The order to the amicus is circumscribed as only presenting arguments in opposition, and there's no suggestion that the court is going to call witnesses or do anything that the parade of horribles that the government and petitioner was laying out for you. All this court is doing is getting advice.
And what standard is an Article III judge supposed to apply in this context?
Well,
in order to assess the motion to dismiss, Rule 48 just says there must be leave of court. So what's the standard that the district court judge must apply?
Well, the governing law here is in Amidon, which is still good law, was cited by Fokker. And there, as Fokker reiterated, I think we have to look at whether the presumption of regularity or there was a clear violation of the public interest for the court to seriously consider whether it can deny the motion to dismiss. So there is a presumption, as you mentioned earlier, and the question is there any basis to overcome that presumption? And that would guide the court's inquiry after receiving the briefing and asking questions of the government and the parties.
But the public interest is not a standard that's mentioned in the rule. And in our constitutional system of government, isn't the public interest with respect to whether a prosecution goes forward, isn't that public interest one that is committed firmly under Article II to the executive branch and to the politically accountable executive branch, not to an Article III court?
Generally, yes, Your Honor. The prosecutorial prerogatives protect and consider the public interest. But in Rinaldi, the Supreme Court specifically held out that standard, I think you know, in footnote 15, where they said they aren't ruling. They are allowing the motion to dismiss be reviewed at the abuse of discretion, and they found that it did abuse discretion. But they said we have not decided whether you could consider a Rule 48 in light of the public interest. And in fact, the dissent, led by Justice Rehnquist, said he thought it was clearly an independent basis to review a Rule 48 motion. But in any event, that law is not clear here. There's no clear and indisputable standard for this court to issue a writ of mandamus based on the fact that the standard is unclear as to how you determine leave of court and any kind of abuse of discretion or discretion. What we do know is in this court, in this circuit court, in Fokker and Amidon, both provided for a review by the court of the government's motion and allowed for questioning. When you decided the case in Fokker, Judge Leon questioned the parties, including the government, in open court on several occasions, and he had conferences. When Fokker was decided, no one stated in that opinion, you cannot ask questions, you cannot have a hearing. And in fact, the government never took Judge Leon up on a mandamus. There's no situation in Amidon.
The government argues that Fokker necessarily rebuked that approach by the district court. What's your response to that?
That's not what Fokker says. What Fokker says is that the district court judge abused his discretion when he denied the motion, which was the speedy trial motion necessary for the deferred prosecution agreement, when he stated that he disagreed with the government's prosecutorial decisions. That indeed is an improper basis to deny a motion to dismiss. and that was the circumscribed ruling of Fokker. Fokker does not deal with Rule 48, as you've talked about, but it certainly doesn't say that you can't have consideration or scrutiny. In fact, it says just the opposite. Throughout the opinion, they talk about the scrutiny and they talk about it being circumscribed, but they certainly don't say the court has no right to ask questions. And here, all the judge is doing is receiving briefing and having a hearing. And the parties, the petitioner and the government, didn't object to that below. Well, they had no alternative. Yes, Your Honor.
How does the presumption of regularity then apply in a situation like this? Before asking questions, appointing amicus, doesn't the district court have to determine that the presumption is overcome?
No, Your Honor. The court could not determine whether the presumption had been overcome without at least questioning the government about its motion. I think Judge Wilkins was pointing that out when he was saying if you had a pleading and the government didn't include all the facts because they only wanted to present certain facts, the court, by definition, would have to inquire to determine whether that presumption was overcome. The court was clear that there is a presumption, so it is a long hill to climb to overcome that presumption. But there's nothing in Fokker that says you may not question the government. And in fact, the government answers these kinds of questions all the time. If you look at Rinaldi, then Chief Judge King of the Southern District of Florida's court called the prosecutors in and asked questions. The Supreme Court in Rinaldi didn't say that kind of questioning was improper. That happens every day in district courts when a party files a motion and a judge asks questions. That's all that's happening here. There's nothing more, nothing less.
Oh, there is more here. There's an appointment of an amicus to oppose the motion to dismiss. That I don't believe is an everyday occurrence.
You're absolutely right, Your Honor, because normally parties are opposed, but here in this unusual circumstance where both parties agree, all the district court did was appoint an amicus to present arguments in opposition to the government's motion to dismiss. And we know, because at least some time has passed, that the amicus filed that brief and did not ask for any witnesses, did not request any fact-finding. So to go to Judge Henderson's point about the regular order, if this court doesn't step into the fray and allows the district court to do its job, it may well be that the court reads both sides, both briefings, asks the government's question, and grants the motion to dismiss.
But who is the amicus representing here? Where the government decided to drop a prosecution and the defendant agrees, what is the standard that they're arguing? Who are they arguing on behalf of?
They're arguing on behalf of the adversarial position, just like this court does often, or the Supreme Court does. One of the most famous cases is Dickerson, where the government was not going to challenge the Miranda standard, and the court appointed an amicus there to argue because the government chose not to take that position.
Right, but so you're saying that there's some kind of judicial right or judicial power here that the amicus is representing?
No, I think as Mr. Wall stated, there's an inherent power, and it occurs at the district court level, not frequently, for the court to appoint an amicus when it needs advice or legal briefing on an issue. But here it's even more important because you need adversarial briefing. The government and Mr. Flynn are aligned.
But I don't know. But that's in a criminal case. That is the adversarial process. It's the government against a criminal defendant. What does it even mean to have an adversary where the government and the defendant agree? What is that? Is it representing some kind of inherent authority of the court?
It's representing the authority of the court to understand the opposing arguments. Just like here, Your Honor, you have the government and the petitioner aligned, and the district court was brought in to argue the other side. It doesn't mean that the district court thinks this motion under Rule 48 should be denied. all we're doing coming forward is arguing the other side. And all the district court was doing is appointing an amicus to say, what is the scope of the authority? Can a motion, an unopposed motion under Rule 48, be denied? And if so, what is the standard, as you've just asked me? The standard is not clear. So what are the outlines? What are the cases? And what do they say about the court's authority to ask questions and to make that decision?
So then the amicus isn't an adversary. You're saying the amicus is to just provide understanding about the law to the district court?
I think the amicus is an adversary in the sense that he was directed to take positions opposing the government's motion to dismiss. So I believe the government and the petitioner would surely see the amicus as an adversary. And that's important because the court doesn't have to listen to the amicus. As Judge Henderson said, the court is an experienced judge. He can ignore the amicus. He can take some of the points under consideration, and then he can ask his questions and make his ruling. But he wanted to hear, yes, Judge.
Sorry. I guess I think here, as you've also recognized, right, there is a core Article 2 power over prosecution. Even the weakest understandings of Article 2 admit that the executive power, includes control over prosecution. But it's hard.
Absolutely.
I think you have to articulate here what is the countervailing Article 3 issue at stake. So, for instance, in the Nixon case, right, there was a conflict between Article 2 and Article 3, and the Article 3 power there that the court articulated was the district court's essential function in protecting individual liberty in a criminal trial. But here, I think, I guess I'm wondering if you can articulate what is the countervailing Article 3 power at stake in a case where the government and the defendant agree on the motion to dismiss.
Fokker laid that out by saying the court is allowed to question the presumption of regularity of the prosecutorial decision even when the defendant and the government agree. Amidon says the same thing. And even in Nixon, Your Honor, the court, citing the framers, made clear that even though you're dividing and allocating the sovereign powers among three co-equal branches, the framers of the Constitution sought to provide comprehensive system, but the separate powers were not intended to operate with absolute independence. And here you've had the government exercising its Article 2 powers, coming in and asking the court to make an independent finding for a plea. They've had the court make a legal finding and a factual finding, and as Fokker says, the court has exercised its coercive power and convicted the defendant. There's a public conviction in lieu of a trial, so the government didn't have to go through that. And that's very important for Article 3 power, that you're stepping into the shoes of the jury and saying, based on this finding, we can adjudicate this defendant guilty. And now the government is coming back and saying, we want you to dismiss those charges and apparently vacate your findings of guilt. It's not clear what they want to do about the actual plea because that's not subject of this mandamus. The plea agreement that is between the government and the defendant, and what the effect of that is if the charges are dismissed. But they're asking the court, the executive branch, to come in and reverse or vacate its findings. And so the court has the right, the duty, and the language under leave of court to ask the government questions. The Rule 48 language that's been in the statute for over 80 years that the Supreme Court suggested and Congress approved, there's not a case since that language went in that says leave of court is meaningless when the parties agree. And that's the government and the petitioner's position. Be clear, they are saying those words mean nothing when the defendant and the government agree. And that makes no sense under all of the cases, starting with Rinaldi. It makes no sense in light of all the cases around the country, where every panel has at least considered whether the court below abused its discretion when they denied a motion to dismiss.
Well, perhaps, leave of court may not be, a kind of rubber stamp, but leave of court is, those words on its own are also, it's hard, I think, to fit into leave of court the ability for a court to keep sentencing a person where the executive branch wants to drop the prosecution. I mean, leave of court may not mean that much, even if it means something more than a rubber stamp.
True, Your Honor, and I think every case has said that it's a circumscribed review, a limited inquiry that a court can do under that standard, but it doesn't say no review. It doesn't say no questions. And the government's position is somehow by the court asking the government questions about the motion that it filed, that somehow that's some irreparable harm. If it is, that goes on in a district court every day of the week. It went on in Fokker, it went on in Amadown, it went on in Rinaldi. The district court in each of those cases asked the prosecutors questions, and they didn't stand up and say, we don't have to answer them. Leave of court means nothing. They answered the questions. They gave the court the information, and the government certainly knows how to refuse to answer or refuse to provide information if it thinks it's appropriate. And this is the reason why this case, all of these issues should have been brought up with the district court below. If the government did not like the process of the amicus or the briefing, or the petitioner didn't, they should have raised it with Judge Sullivan. And instead, they then run the district court and come to you.
Counsel, the government says that with respect to kind of the case or controversy and the Article 2 prerogatives and how Rule 48A is supposed to work, that even if the government in a motion says, you know, we're moving to dismiss because we don't want to prosecute this white defendant for beating and using excessive force against a black victim, that the court would still be compelled under Rule 48A to grant the motion to dismiss, and that the remedy, if any, for that sort of unconstitutional bias would be, you know, defendants in other cases filing some sort of Armstrong motion, or I guess some, action by other branches, you know, after the dismissal to reprimand the executive. What's your response to that point of view of Rule 48A?
It won't surprise the court that I strongly disagree with that. The case law that's already well known by this court, starting with Rinaldi, and the cases around the country give examples of where a court can deny a motion, which include bribery. That's not even a constitutional violation. You just heard Mr. Wall mention it a few minutes ago. And all of those cases provide that could be an example where a prosecutor was bribed, and likely, if that were true, he's not going to put that in the pleading in the motion to dismiss, and that could cause a court concern and could be the basis for a motion to dismiss. So if the government was acting in a racist way and either gave those bases to the court, or the court was able to uncover them through questioning, yes, that would be a basis to dismiss. The next question is, then what could the court do? It would depend on the posture of the case. If it was an early decision in the case and the defendant actually hadn't pled guilty, then there's more limited options. But as you said, there's still public pressure that can come as a result of the courts issuing that motion. But if the defendant had pled guilty, the more difficult question, or the more interesting question, is the Article 3 court now has supervisory power over that defendant. As Fokker says, once you have a guilty plea, the court has jurisdiction over sentencing. So the question is, if that police officer had pled guilty and the government disagrees with the moving to the dismissal and the court denies it, could the court sentence that defendant? I don't know the answer to that question, but there's certainly a basis for the judge to deny the motion to dismiss on those grounds.
Thank you.
The district court is not acting as a prosecutor, Your Honor, nor has he made up his mind about the pending issues. He is considering the government's motion and receiving briefing from all the parties. After hearing the arguments, Judge Sullivan will do what he is called on to do on a daily basis. He'll decide the motion. With such a combined inquiry, there is no clear and indisputable justification for this court to enter the fray now and stop a federal district court judge from carrying out his Article III responsibilities. Thank you.
All right. Any more questions? All right, Madam Clerk. Neither counsel has any time left, right?
Correct.
All right, Ms. Powell, why don't you take 2 minutes?
Your Honor, first, there were no valid Rule 11 proceedings in this case to take the guilty plea. But mainly, the first judge who took it should have recused already. He mysteriously recused a few days later, but for the same reasons that would have existed when he recused 7 days later, he should have recused immediately, and the government knew that information, but General Flynn didn't. The second guilty plea colloquy that Judge Sullivan did was not a full colloquy at all. In fact, he ended it by asking repeated questions, saying he had many questions, including about how this was material and how it impeded the government's investigation. All of that is now refuted completely by the extraordinary exculpatory evidence that Mr. Jensen disclosed that has been hidden from the defendant for 3 years. That's what makes this case different from every other case. When that happened in Stevens, Judge Sullivan had no problem dismissing the case at all. He didn't inquire behind the government's 2-page motion to dismiss. They simply produced the evidence and dismissed the case. Why we're making a special exception here for General Flynn is beyond my capacity to understand the law when every case in the country has affirmed a grant of a motion to dismiss and not denied one in any way, shape, or form. I mean, every appellate case in the country has affirmed the grant of a motion to dismiss or has said the case has to be dismissed. They don't have any ability to go question behind the government's perspective on why it made the decision, absent an Armstrong problem, which clearly doesn't exist here, or clear evidence, not plausible questions, not amusings, not imaginings, but clear evidence of some serious wrongdoing that indicates bad faith on the part of the government. And Rinaldi makes clear that the leave of court provision was included to protect the defendant from prosecutorial harassment. There is neither a case or controversy here any longer. The government and the defendant have agreed that the case must be dismissed. The government is not going to carry on the prosecution. It cannot be forced to by an Article III court that's outside its bounds. And the motion for writ of mandamus should be granted on all counts.
All right. Thank you, Ms. Powell. Mr. Wall, why don't you take 2 minutes?
Judge Henderson, can you hear me?
Yes.
Thank you. So just a couple of very brief points. I didn't hear respondent address what I think is the central point on the merits, which is that once they've conceded that Fokker does not allow the court to go any further with respect to the pre-plea situation, because there's no way to make the executive proceed with the prosecution. And once we know that as a Rule 48 in a constitutional matter, there's no way to force the government in that situation, they don't have any argument, either as a matter of reading the rule and interpretive principles or constitutional concerns, that would distinguish the post-plea situation. That's just not what Rule 48 is meant for, and I think Fokker's clear about that. So then really they've hung their hat on just the notion that it's too early in time. And as I tried to say earlier, I think, Judge Henderson, there are real harms that are going to come from the kinds of questions they want to ask. I mean, in the brief, they say they want to ask about the uncharged conduct. So not just why we no longer want to maintain this prosecution, but why we haven't brought separate charges against this defendant. Everybody, I thought even respondent, conceded commencement. Prosecution was off the table, but they want to ask about uncharged conduct. They want to ask about related prosecutions. They want to ask about why certain prosecutors signed particular briefs, whether they agreed with our position, whether they didn't. They want to ask questions on the reasons that the Attorney General gave, like his policy judgment that the federal interest is no longer warranted. And if the court thinks about the manner in which we are going to have to answer those questions in the district court, what we are going to have to say, whether as a factual or as a legal matter in terms of disclosing our own deliberative processes and the like, I think it's fairly clear why Fokker said courts were not supposed to go down this road. And I take the point that the train isn't at the end of the line, that it's only partially left the station, but I think that's why Fokker said the train's never supposed to leave in the first place in order to respect the division of constitutional authority between the executive and the judiciary in light of these Article 2 and Article 3 concerns like the ones Judge Rao was raising. There are real harms here, and if we know what has to happen at the end of the day, with all respect, the district court should be directed to do it now rather than have some unnecessary and very harmful further proceedings.
Mr. Wall, let me ask you something that is, I think, in your brief, but I don't think you mentioned it this morning, and that is the harm to Article 2, perhaps not harm, but the benefit of self-correction. On this record before us, if there was bad faith, it occurred in the original prosecution. And shouldn't we allow Article 2 to self-correct?
Absolutely, Judge Henderson. And I think, again, this goes to the question Judge Wilkins was asking earlier. Even if we could legally come in and not give any reasons for the motion, we did give fairly fulsome reasons, and the Attorney General had three independent rationales. And although they've challenged two of them on sort of legal bases, no one, not the court-appointed amicus and not the respondent, has said a word about the portion of the motion where the Attorney General says that looking at the circumstances surrounding the FBI's interview of General Flynn and the way it went on and the way it wasn't communicated to others at the White House and all the rest, that he concluded that it was no longer in the interest of justice to proceed with the prosecution. Now, the reason they don't say a word about it is because I think no one disputes that that is the kind of judgment that is at the core of Article 2 power. It's difficult to imagine, at least outside the military context, a more core Article 2 judgment. And yes, Judge Henderson, when we put that forward in the motion, whether we were required to or not, absolutely, I think that at that point, the district court is required to grant the Rule 48 motion.
All right, thank you. Do my colleagues have any questions?
No.
No further questions.
All right. All right, counsel, your case is submitted, and Madam Clerk, if you'll adjourn court.
This honorable court is now adjourned until Wednesday, September 9th at 9:30 a.m.
All participants are now in interactive talk mode. We're sorry, your conference is ending now. Please hang up.
Wow, what did we just witness, guys, huh? What do you think of that? Shady, welcome. Wow, what did we just witness, guys? Oh, wait, how come I'm on? Wait, that's me. What do you think of that? Sorry about that.
Hey, Mel.
Yeah, hi, guys. Shady, what are your thoughts on what we just witnessed here?
Man, I am just over a barrel with listening to that.
Yeah. It's almost like straw man cases. They brought up race for whatever reason. And I have a question. You know, they talk about all these cases. Fokker, right? Meet the Fokkers. And did the DOJ resign in those cases is my question.
Nope.
Nope. So if there was no DOJs, they can't produce the 302s that they probably forged, so they had to burn them because that would be self-incriminating. There's no frickin' case.
Yes.
Right, and hat tip to Sidney Powell for having to deal with all this crap. Oh my God, I didn't realize how much crap she has to deal with on this. So let's just go back and look here. There's 48 drops that mention Flynn. Okay, and you know the latest one here is pretty damning right here. And if we get these indictments or subpoenas that we feel that we're going to be getting here soon, Shady, all these people, there's no case, Shady.
There's no case, and all these people are going to be brought up in front of the Senate to prove that there's no case.
Under oath.
Yes, this is. I mean, what we were just witnessing was a good lesson on the swamp.
Yeah, absolutely. I 100% agree.
Because
There was one
because
judge.
They were not addressing what Sidney Powell was bringing. They were not addressing what the defense was talking about. They were going round and round in this circular motion to justify themselves. They're pretending like they're too stupid to understand, so they can't make a decision.
That's right.
Is what it looked like to me. And like you just said, kudos to Sidney Powell, because this is unlike anything she's ever seen as well. It's not just us.
Right.
She's been doing this for whatever distance. And, she mentioned there that the original judge recused. They brought on Judge Sullivan. So that's a bit of a red herring right there already. And then with her experience with Judge Sullivan on the Stevens case, she kind of was thinking that he was going to understand and march along the same line of thinking. But now we're seeing that this case is obviously much different, much more swampy, and they know that they're exposed if this case is dismissed, man.
That's right. I mean, it's
not just the DOJ.
No, it's not. It's everybody. I mean,
it's FISA court.
It's FISA court. It's Obama administration.
Yes.
Sally Yates's attorney was involved. I mean, swampity swamp. I did a little research on Judge Sullivan, and he went to Howard University, and that is a very big social justice radical university, Shady.
It is, and also realize that John Roberts is on the FISA court as the Chief Justice.
That's right. Yeah.
So, we have a big problem in the idea that, the judges don't understand the law. There is no case here, man. There is no precedent for this. No one has ever seen anything like this in the court system since the beginning of our republic, guys. What you're looking at is a monarchical tyranny. This is tyranny. The government has withdrawn. The executive branch has removed itself from the case. Therefore, the contract between the government and General Flynn is null and void because of no participation. They both agree that they do not want to proceed, and you have swamp interjecting itself and causing more distress and harm to a defendant.
That's right. And let me quote General Flynn. There are some seminal moments in American history that tests every fiber of our nation's soul, and we are facing one now. And that was General Flynn, 6/11/2020. God bless General Flynn. We're praying for him and his family. Shady, I just can't believe what I'm seeing here. I can't believe what we witnessed. I really can't.
Obviously, it looks like they have diverted back to Judge Sullivan and July 12th?
Yeah.
Is that what, that was the date, I think, that was set there.
Yeah, I believe it is in July. Yes. But I tell you, it was getting hard to listen to. It really was. This one judge guy going back and forth with crap that doesn't even matter, talking about a gentleman that was of a different race, black, bringing that up for what? What does this have to do with anything?
Well, it doesn't really have to do with anything. They're trying to reference the case of Fokker, but that case doesn't have anything to do with this because it isn't a case where the state recused or the state dismissed or let the case go.
That's right.
It's not relevant. It's like I was actually thinking that Sydney was going to jump in there and start flogging them, but I think that with the way she commented there at the end, she knew where this was going and what they were going to do, and just to defer this back to the original court,
right?
Which is a disappointment, really.
Yeah, it is a disappointment. We were hoping that something better would come. Let's check this out. This is General Flynn. Let's watch this, guys.
My passion and my destiny changed when I saw our country taking a fundamentally different direction in a world filled with challenges and challengers. And we see them out there all over the world today on the news every night, etc. And I decided to do something about it in a different capacity. If I'm paying a price for that decision, so be it, and God can and will judge me at some point. My passion.
And you know what his passion is to defeat radical Islamicism, which is what the Democrat Party is standing for and by now, Shady.
Yeah, and I think that everyone can see it because what you're watching in your cities and in your municipalities is the relinquishing of power by the government to the mob. Okay, the mayors are relinquishing their power to the mob. The governors are relinquishing their power to the mob, as if scripted and right on point and timing.
That's
this
right.
is coordinated in the background. And General Flynn talking about infiltration, he's not kidding. It's not just infiltration like people are standing around on the street corner. It's infiltration like they're judges, they are prosecutors, they are attorneys general, they are all over the place and consistently fighting against our system that we so respect and love. You know, I'm going to be the first to say, coming out of high school, I didn't think things like the Electoral College were necessary. But by the time that I turned 30, I had changed my opinion on that because I understood my system of government better because school didn't teach me my system of government. But we're seeing something unprecedented in this case, and let's hope it doesn't set precedent, because that's what cases do, is they set precedent. And this is a debacle, and this is unlike this has no bearing on our republic whatsoever. If the government is withdrawing, the executive branch is withdrawing from the case, there should be no further prosecution. When have you ever heard of a judge prosecuting a defendant?
Absolutely.
No sense.
It doesn't make sense. And, Jonathan Turley on June 10th wrote an article called The Flynn Court Drifts Dangerously Outside of Judicial Navigational Beacons. I mean, this is a great article, and he's absolutely right. This is the column that was in USA Today over the recent orders of the U.S. District Court Judge Emmett Sullivan, as leading lawyers, including a former Clinton U.S. attorney, openly advised Sullivan on how to make trouble for the administration. They do that shit. This is we hate Orange Man syndrome, protecting Hillary Clinton's emails syndrome, understanding that Flynn knows where the bodies are buried syndrome. We, the people of the world, know. I mean, these calls only magnify concerns over the purpose of these proceedings and whether they are increasingly detached from the merits of a pending motion. While many seem to relish the improvisational element, they risk undermining the judicial element of the proceedings. Flynn's team has sought to remove the removal of Sullivan, a very difficult proposition, particularly in the D.C. circuit. The intense opposition in the bar and teaching academy to Trump seems again to have greatly distorted any legal analysis, which fails to address the most troubling acts of these orders. As I have previously acknowledged, there are good faith arguments to be made, but much of the analysis has ignored the strong precedent against the denial motion and rarely even acknowledged the serious implications for the rights of the defendants in such actions. So it continues, I address some of the countervailing and, in my view, controlling authority in separate posting. Notably, the D.C. Circuit gave Judge Sullivan 10 days to respond to the motion seeking his removal. Thus, these issues will presumably be addressed by Judge Sullivan before any hearing is held. And then here's his column right here. It's just Will Chamberlain, who's a D.C. lawyer, understands what's going on here. People see this, guys. This is just, I just can't. I just can't, Shady.
Well, I have a question. You know, Cindy C out there said, can't the president put an end to this? And the answer is yes, the president can put an end to this, but we want optics here. We need optics here. We don't need it to look like the president pardoned General Flynn and then brings him back in his administration. That's terrible optics. We need this case dismissed per merit so that we can plainly show that there was never a crime committed.
So apparently, let's look at this too. This is Will Chamberlain, John Gleason, arguing that General Flynn should be sentenced in spite of a government moving to dismiss his case, cited an unpublished online law review article. Look at that. Forthcoming. This is that 48A that they were talking about, guys. Rule 48A was designed to guard against dubious dismissals of criminal case that would benefit powerful and well-connected defendants. And then why do 48A dismissals require leave of court? In extraordinary development on May 7th, 2020. The Department of Justice has asked United States District Judge Emmett G. Sullivan to dismiss a felony charge against President Trump's former national security. So basically, this was shady. This is just messed up.
Yeah, no, and I'm going to drop the Epoch Times article there to you guys here, but also Gleason was recommending that Sullivan need not go through the process of determining whether Flynn committed perjury or not, but it could simply assume that he did and proceed to sentencing, factoring the defendant's contemptuous conduct into the appropriate punishment. Now that is Gleason's position on this, who is the judge that Sullivan brought in. He's basically saying that Flynn doesn't have the right to withdraw a plea.
No. Yeah, and it's a complete disregard for the justice system. Yeah.
Did you notice how much none of them talked about General Flynn?
Yeah, they only talked about Fokker.
They weren't talking about exculpatory evidence. They weren't talking about missing Brady evidence. They weren't talking about being illegally prosecuted. They weren't talking about his due process being usurped. None of that was an issue. It was all talking about these other cases where we've got all these little judge magic spells that we can work on people.
Right.
For lack of a better term.
Right. And here's the Epoch Times. Let's go to that. So this is the DOJ chastises judge for delays usurping executive power before key hearing. And this was yesterday. In the lead up to the crucial hearing in the case of Lieutenant General Michael Flynn, his lawyers and the Department of Justice excoriated a federal judge for trying to delay the case's resolution and usurp prosecutorial power. The game is over, and this court should order the umpire to leave the field, Flynn's lead lawyer, former federal prosecutor Sidney Powell, said in a brief to the District of Columbia Appellate Court, asking it to rein in District Judge Emmett Sullivan, who's presided over the Flynn's case. The court set a hearing in the case for June 12th, and that's what we just saw today. Flynn's former head of Defense Intelligence Agency, that's who he was, right? During the Obama administration, and former national security advisor to President Donald Trump, pled guilty in 2017 to one of the court's lying to one count of lying during an FBI interview. In January, he disavowed the plea and asked the court to allow him to withdraw. The DOJ moved to drop Flynn's case on May 7th, saying FBI didn't have proper reason to interview Flynn in the first place, and seemed to only do so to elicit those very false statements and thereby criminalize General Flynn. So, shady. He disavowed a guilty plea where it didn't have a place to be there anyways because it wasn't the proper. He wasn't under oath. He was just, remember his. He was just trying to do the right thing. He was trusting his deep state lawyers, shady, to do the right thing.
And that's another point that they don't even bring up.
Right.
You know, the idea that all of this should be relevant to the defendant's due process, but somehow it's become relevant to the court's agenda.
Mm-hmm. It has. So let's maybe look at Emmett Sullivan, right? Do you know what else he's done in the court system, Shady?
Let's see.
It's quite interesting. Let me go to Wikipedia. Okay. There he is right there. There's Judge Emmett Sullivan. He's the United States District Judge of the United States District Court for the District of Columbia. He earned his undergraduate and law degrees from Howard University. He worked in private practice for more than a decade at Houston and Gardner, becoming a name partner in 1980. He was appointed to the bench of Superior Court of the District of Columbia in 1984 by President, Ronald Reagan, to the District Court of Appeals as an associate judge in 1992 by George H.W. Bush, and to the federal bench by 1994 by, Shady, I wanted to put him, on the federal bench, Bill Clinton.
Yeah, I bet.
Yeah. So this is his education and career. He did do Howard University. If you do a little lookup and a little background on Howard University, it's pretty interesting. He joined this firm called Houston and Gardner, where this page does not exist, just so you know. He was nominated by Bill Clinton. There you go. Notable cases. Let's look at this, Shady. So Sullivan presided over a number of habeas corpus petitions in the 21st century, submitted on behalf of men detained by the United States military at the Guantanamo Bay detention camp as part of George W. Bush's response to the 9/11 attacks on terrorism. Sullivan presided over the 2008 trial of U.S. Senator Ted Stevens, who was convicted of 7 felony ethics violations in October. During the trial, the judge refused requests by the defense for a mistrial to be declared after information was revealed that the prosecution withheld exculpatory Brady material. 8 days after the guilty verdict, Stevens narrowly lost his re-election bid as more evidence of prosecutorial misconduct became known in early 2009. Judge Sullivan held 4 prosecutors in civil contempt of court. On April 1, 2009, following a Justice Department probe that found additional evidence of prosecutorial misconduct, the Department of Justice recommended that Stevens' convictions be dismissed. Shady. Sullivan set aside the conviction and appointed a lawyer to investigate the prosecution team for criminal contempt. So this seems like a playbook, doesn't it, Shady?
Really does, doesn't it?
Mm-hmm. So subsequently, one of 4 prosecutors held in contempt committed suicide. He ruins lives, Shady. Ultimately, Sullivan dismissed the civil contempt charges, and no charges were brought against the 3 surviving prosecutors. In 2014, guess what? Sullivan was presiding over a case with Judicial Watch versus the IRS. Do you guys remember the IRS crap, Shady?
Yep.
Yeah. So why would they want to prosecute Judicial Watch? Because they're asking for a lot of FOIA, right? And they wanted to do the taxes. So they went after patriot organizations and foundations and organizations for taxes, okay? This is what they did. And this is related to an ongoing investigation into the 2013 IRS controversy. There was a fruitless attempt to determine where the deleted emails of former IRS employee Lois Lerner had gone. Where's the 302, Shady? That's gone too. That was deleted.
Yep.
So what damage to her computer hard drive occurred, and what steps the IRS taken to recover information contained in the emails on the hard drive? And we all know in 2013, let me just tell you, they have it. It's nothing's ever erased, guys. I mean, your backup systems, it's called, storage, data storage, okay? In 2015, Sullivan presided over FOIA lawsuit involving the matter of Hillary Clinton's private email use while Secretary of State. Shady.
Very, very interesting.
According to the ACLU, a woman and her child domestic abuse in El Salvador to seek asylum in the U.S. That's another one. The mother was removed from detention facility and likely put on a plane in August 2018 despite Justice Department promises. But let's go to this one, Shady. Blumenthal versus Trump. As district court judge, Judge Sullivan presided over a lawsuit involving President Trump, which challenged payments by foreign governments to Trump-owned hotels. Sullivan granted in part and denied in part the Trump's team motion to dismiss for lack of standing. Why can't he ever dismiss anything, Shady? Denied.
It seems like he likes to hold on.
Yeah. Denied the motion to dismiss for failure to state claim and certified interlocutory appeal. On February 7th, 2020, in a per cuium decision, the United States Court of Appeals for the District of Columbia Circuit held that the individual members of Congress lacked standing to bring action against the president. The court, finding in favor of Trump, reversed and demanded Sullivan's holding that the members of Congress had standing to sue and instructed him to dismiss the complaint. And here we are.
So on the wrong side of the law again.
Or on the wrong side of the law again. What a great track record he has for the deep state.
And I'd just like to make everybody aware of, a few of the intricacies of these judges. These guys usually do not live in D.C., but they stay and work there. They stay and work in complexes that are very close to each other, and they talk to one another. They are friendly with one another. They are in a little sorority or fraternity or whatever you want to call it.
Secret society.
A secret society. Okay. They are there for a reason. They are handpicked for a reason. And that's why you're seeing something unprecedented right now, because they're going against your Constitution. They're going against your country. They're going against due process because they have no choice. And whenever a mob comes to a point where they can't reasonably discern or argue, what do? They act outside the law. And that's what they're all doing. And notice we had from Kamala Harris to Cory Booker to every one of them standing up there saying, no man is above the law. No man is above the law.
Right.
This guy right here is acting above the law.
Yes, sir. Wow. Wow. Look at that, Shady.
FISA court, FISC court, all that stuff needs to be dissolved immediately. This is BS. There's no precedent for it. We will use normal systems to investigate foreigners. Get rid of FISC, get rid of FISA, because that gives people like that right there a platform to attack Americans.
You mean Robert Swan Mueller III?
I mean, exactly. Mr. Swan Mueller.
Should be Swamp. I think that should be an M and then a P after that.
Yeah, Robert Swamp Mueller
the third. Because there's two more.
The third in a long line of swamp.
Where there's one, there's three.
we've now perfected the swamp.
Yeah. So guys, I'm telling you, what we just witnessed is amazing, guys. I'm telling you. There's nothing I can say. And here's Brian Cates understanding it as well. If Mueller is involved with this, I mean, right there, in the special counsel, we know that was crap. And under oath recently, everybody said, hey, there was no collusion, there was nothing, yet here we are, because publicly they're lying. Chad Calderon, you're so over it, so are we. But I do believe, as I think Shady said before, that we have to actually, get through this, right? To get through this, to get organically, Shady, if you will.
Yeah, I mean, to me, I think that a lot of, I'm just speculating with what I'm about to say, but I think that a lot of the stuff to move forward, whether it be sealed indictments or swamp creatures being arrested or Durham's indictments coming out, all of those things, I feel like hinge on this case with Michael Flynn, with General Flynn. I think that's just part of the reason that we haven't seen as much as maybe we would have liked to have seen. And I think the deep state knows all about it, and they're all in on keeping this case open at least as close to the election as they can get. That's what they're trying to do. They're trying to squeeze this as close. They know there's no recourse here. They know what the end result is. They know what the end is, but they're delaying intentionally to harm our ability to red pill the masses in America with the truth. Because once General Flynn is done with this, he can go to a podium anywhere and he can talk all about Covington and Burling, and he can talk all about how Mueller and the guys set him up and they were going after his son and threatening to put his son in prison for nothing and stealing all of his devices and investigating everything under the sun about President Trump. All of that stuff will be open source as soon as this is dismissed.
Yeah, I want to share with you a meme that a good friend of mine shared with me. Check that out. That's a wave, America. Somebody that loves surfing, and there's Big Sur in the background. And oh, by the way, did you notice that our General Flynn's Twitter banner changed? Did you guys see that?
To the balanced scale.
Yes, let me grab that for you guys. And then I want to share something with you that somebody very special shared with me. And we'll share that with you guys real quick. But look at this. There's General Flynn right there. That's what we want. We want real justice, okay?
Equal justice.
Equal justice under the law. Now I want to show you General Michael Flynn accepts award for service to America in September. I want to share this with you as somebody shared it with me. Here we go.
And pretty humbling. It's an interesting thing about my mother, Helen Flynn, who's just she's deceased now, but she was just a terrific person. And how me standing up here today is really such a small world, because her and Phyllis's life intersected in the 70s. And I remember going down to Washington, D.C. early in the 70s there for the Right to Life marches that my mother would stick us on a bus and we'd all drive down, or she made me drive floats in parades, Right to Life floats in parades. I took a lot of beer bottles, I'll tell you, that were thrown at me. But it's interesting how people intersect in life, and then here we here I stand here tonight, and it's really it's a pretty awesome experience. The entire Schlafly family that's here, it's so gratifying to see that the fact that you brought your children with you. And I think that that's such a neat thing. And I think that our country is so much better because of your mom and what the impact. I mean, she's really iconic when it comes down to the kinds of things that she got herself involved in. And I think for certain types of people like Jack Singlaub, and I'm going to make some comments here in a little bit about, and just talking about some things that we believe in. You don't, even when a person is gone, their legacy continues to live on, and their real impact, you really don't know what that impact will be. You don't know what it is yet. We don't know what it is yet. And some of it is sitting in this room tonight. And like Ed and I were talking earlier today when we went over to visit the Schlafly Center, you know, who's the next Phyllis Schlafly? Where is that person? And Ed's comment back to me was, you know, maybe there's 12 of them out, maybe there's a dozen of them out there somewhere, but who's the next one? And there has to be more Phyllis Schlafly type people to continue to carry this gigantic message that we have for our country. So I think for the family that's here tonight, thank you so much. Thank you for continuing to move this message forward and to move this whole dynamic that your mom left for us to carry on. And for Ed, I really appreciate your interaction with us, my family, and we appreciate it. I also want to recognize the two daughters that were just up here of Jack, and I spoke with Jack and Joan a day or two ago. And I think for Deborah and Jody, I don't know where you're sitting at. Where are you sitting? Yeah, I'm sorry, right here. I think for the two of you guys know what I'm talking about when you're talking about your father and you're listening to Ed describe him and all these escapades and all these kinds of things they get involved in. But if there's two people, and I had called your dad back, I think it was July 11th, which was his birthday, and I called him up and I wished him a happy birthday, and this past couple of months ago. And of course, Joan answers, and I mean, it's like if you saw these two people, and especially if you saw General Singlaub, I mean, he could fit in his uniform today, and he could command a rifle battalion in the 82nd Airborne today. I mean, he's that strong, you know. The guy's unbelievable. He's amazing. He's really amazing. Anyway, so I want to make sure that I'm very precise, because I know there's going to be a lot of people that will, especially in the back row there, that will pay attention to whatever the heck I say, and want to make sure that they get the words that I say right, because I really believe in the things I'm going to say. And like I said, I spoke to General Singlaub this week about serving America and what it means to both of us. And I want to share some of our thoughts with all of you tonight. Service to America requires us, today and tomorrow, to stand together as champions of freedom and soldiers of liberty who are on the right side of history. Anything less cannot be tolerated if our country is to survive. For many of us across our nation, we understand that this is not the first time that patriots have risen to this fight that we're in today. More than 200 years ago, more than 250 years ago, Patrick Henry, a great patriot who understood service to America, he warned his fellow countrymen that his choice against Great Britain's suppression of freedoms was crystal clear, as mine is tonight, as he described whether to accept slavery to a monarch or freedom. Seems like an easy choice. Almighty God, he said, I know not what course others may take, but as for me, give me liberty or give me death. What an amazing thing to say at a time for our birth of our country. Another great servant, Abraham Lincoln. Abraham Lincoln fought for his vision to unite the North and the South as a new birth of freedom, so that all people would be treated equally without regard for color or race. In his very famous Gettysburg Address of 1863, at the dedication of the Soldiers' National Cemetery to honor Union soldiers who had died in the Civil War, Abraham Lincoln, President Lincoln, he inspired our nation. He inspired Americans to fight on so that these dead shall not have died in vain, and that this nation, under God, shall have a new birth of freedom, and that government of the people, by the people, by you, by the people, for the people, shall not perish from the earth. Nearly, in fact, just slightly over 100 years later, in his 1964 speech at the Republican National Convention, another great American servant, and subsequently President of the United States, Ronald Reagan, he redefined the very essence of why the fight by Americans against tyranny and injustice will never end, must never end. Reagan said, quote, "Freedom is never more than one generation away from extinction. We didn't pass it to our children in the bloodstream. It must be fought for, protected, and handed on for them to do the same. This time, our America, the urgency to act is at the doorstep of our democracy. The future of this country depends on each one of you in this room tonight and many, many others that you represent around our great country. This turning point is about the heart and soul of the United States of America. You cannot and must not be silent or take for granted that our great nation will not fall to the many threats that we face around the world, and some right here at home. It is time. It is absolutely time. It's time tonight. It's time this weekend. Never a better time. But it's time to buckle down and listen up and stand ready to fight for our way of life and our traditions. For those who oppose our fundamental principles could take us down in the snap of a finger. In my book, The Field of Fight, I stated, and it's on page 111 for anybody that wants to look if you got the book. I stated that we should not fear the Judeo-Christian principles that our nation was founded upon. We should not be in fear of that. We should cherish that. We should believe in that. We should be incredibly proud of that. I will always believe that. To those in the room this evening who have served in our military or serve as first responders, you represent our warriors around the world and across our country. And you all know what your respective battlefields look like. They are not pretty, and they are not perfect, definitely. And we fight or serve America not because, this is super important, we fight or we serve America not because we hate our enemies. It's because we love our country. We absolutely love the freedoms that we cherish. When we talk about why we fight, why does a soldier or a Marine or an airman, why do they do what they do on the battlefield? And it's always about the buddy next to them, the person on your right or your left. Deep down inside, it's about the way we want to live and the way we must continue to fight to live for. Super important. Our fight for individual freedom and liberty, as I described a little while ago, will also not be pretty nor perfect. We will be measured harshly. Trust me, we will be measured harshly, and our enemies will try to destroy us, but we cannot fail. There are moments in history that are seminal, and then there are other moments that are monumental. Major General Jack Singlog was present at all of these. And he was present at all these during most of the last century. I mean, like I said, the guy, he was 97 years old. The guy, I would not want to meet him in a bar fight tonight. He's a pretty incredible human being. And thank God our country has people like him. He always, 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 always responded to the call to serve, the call to duty. And in his way, with his gifts, his intellect, his courage, and his belief system, he served our country and continues to serve our country. I'm standing here as a reflection of Jack Singlove because of his service. Jack served our country with distinction, with honor, integrity, and with dedication to liberty and freedom. But above all, he dedicated his life to God, he dedicated his life to his family, and he dedicated his life to our country, the United States of America. So on behalf of Major General Jack Singlove and for all of his tremendous years of service and his service to America, I humbly accept this award. I commit to General Singlove and to you tonight that I will never stop fighting and that I will never stop believing. Our nation and its very existence are always at risk to tyranny, especially tyranny around the world. My pledge of allegiance and my solemn vow is to our beautiful country, its flag, and that pledge will never waver. My pledge will never waver. I know all of you feel the same, but every so often, it's good to be reminded. So to all of you, thank you so much. Thank you for this honor.
It's your General Flynn right there.
And I hope you enjoy this great week.
And Shady, I wanted to also play one more video as well, unless you got some commentary on that. Because I want to show you why General Flynn is actually in the situation he's in right now.
Yeah, I think that's all pretty self-explanatory right there, my friend.
Yeah. So the reason why this gentleman is in the situation he is in right now is because of this. And they spied on everybody that was against this. All the Democrats are supporting this ideology. Ready? Here we go.
Islam is a political ideology based on a religion. So this is a political system that we are facing, and we must defeat this political system.
This is why we're here. This is why he is in the predicament he is in right now.
When you are facing an adversary, okay, which I have faced these guys and also other adversaries of our country, you cannot sit there and go, geez, I don't know who, I wonder who these guys are, sort of twiddling your thumbs. You can't sit there and say, I can't clearly define this enemy, because when you cannot clearly define the threats that you're facing, you then cannot develop a strategy to defeat it. So you must clearly, precisely, and thoughtfully define the enemy that you are facing, that we are facing. We are in a war. It's a war declared by our enemy. And our government does not allow those in government to be able to clearly define what it is that we're facing. Radical Islamists and radical Islamism. Isms that we faced over the last 75 years, Nazism, fascism, communism, now it's radical Islamism. It is a cancerous, barbaric, vicious form of element inside of the Islamic system. Islam is a political ideology based on a religion. So this is a political system that we are facing, and we must defeat this political system, the cancerous form of this political system, which is this radical Islam.
And I saw somebody say Zionism. Well, the Zionists are now supporting radical Islamicism.
It's the same thing, guys. And it's the same thing as cultural Marxism. It's the same thing as, all of it, communism. It's all the same thing. They have to continually move it under different umbrellas as they move through time, trying to implement it in the world. And notice that they've been able to implement it into the world, every single country except for America. And look at the effort they are putting forth. I mean, think about what's going on with autonomous zone in Seattle. You think that those aren't going to be coming to other cities? They're going to attempt to set this up as a separate country, guys. They're seceding from the Union is what they're attempting to do. They're attempting to do what was done to us in the Civil War.
Yeah. Mike P. says the 3 world wars. We read that about a year ago, Pike's letter to Mazzini.
Sure.
And yes, we are in the 3rd World War, where they unleashed the nihilists and the atheists to degrade our belief system here, Christians, and bring in a new religion, and they want to bring in the full light of the Lucifer, guys, where it's, when everybody doubts each other. We're there right now. Albert Pike's 3 World Wars. If you want to read it, Google it. It's very amazing. Written in 1871, I believe.
Yeah, late 18 something.
Yeah, so interdasting faux show, and this is what they want to bring in. And then look at this, guys. Here we go. Let's watch this guy.
But for more than 3 decades, I have also had the tremendous fortune to travel the world, and as part of that experience, to learn about the goodness and beauty of Islam.
Oh.
As a college student in the 1970s, I spent a summer traveling through Indonesia, taking in the wonderful landscape, culture, and people of Java and Bali. Despite my long hair, my earring, and my obvious American appearance, I was welcomed throughout that country in a way that is a reflection of the tremendous warmth of Islamic cultures and societies. Like the president during his childhood years in Jakarta, I came to see Islam not how it is often misrepresented, but for what it is, how it is practiced every day by well over 1 billion Muslims worldwide, a faith of peace and tolerance and great diversity.
Peace.
And if you permit me, or I should say, اسمح لي, بعد إندونيسيا سافرت إلى مصر وهناك درست عربية في الجامعة الأمريكية في القاهرة، وهذا في سنة 1975 و76. وسافرت إلى الأردن وفلسطين والقدس وتونس، وبعد مصر ساكن في الشرق الأوسط تقريبا 6 سنة، لكن الآن أنا أجوز. أنا كنت طالب وشباب لما درست عربية، لكن الآن نسيت أكثرية اللغة. كسلان، لسان كسلان. متأسف، لكن ممكن إن شاء الله سوف أدرس عربية مرة تانية إن شاء الله. عفواً.
Interesting, huh, Shady?
Yeah, interesting.
Then we got Valerie Jarrett, Iran. We've got Huma Abedin, right? Iran. We've got Peter Strzok, like you mentioned, yes. You can...
We got Lisa Page, Iran connections.
Yep, Lisa Page. So, do you understand what's happening here, guys?
2 factions fighting each other.
Right. And this is what our president is trying to get rid of, this garbage. Now, you can call it communism, whatever, but it is radical Islamicism. The Muslim Brotherhood, guys, is in our country, and it was deemed a terrorist in Jordan. It's a terrorist group in other countries, guys, but not here. Instead, we got them here.
Yeah, the history of this, the history of quote unquote Islam is very modern in the faith category.
That's right. And also, it seems to me that we found out that there was a mystery man, the root of the Nation of Islam. It's interesting. Is the guy's name is Fard, F-A-R-D. And if you kind of listen to when POTUS was talking about Ford, it almost seemed like comms, guys. So I think we need to basically dig on Fard, F-A-R-D. Fard was the leader of a temple and was brought upon him when Thanksgiving Day in 1932. One of his followers, Robert Harris, renamed Robert Kareem, committed a human sacrifice in order to bring himself close to Allah. Kareem cited a quotation from the book titled The Ritual Secrets of the Lost and Found Nation of Islam, authored by Wallace D. Fard Muhammad, which read, "The believer must be stabbed through the heart." And this is the founder of the Nation of Islam that, Farrakhan belongs to. Sharpton belongs to, but he's fooling you saying that he's a Christian. The gentleman that we saw on Hannity the other day when he was calling my brother, that guy, the brother. It's the Brotherhood of Muslim Brotherhood, guys. And if you look at Q-Post and put in Brotherhood,
lots of MB.
Right? So Muslim Brotherhood is 16 times. And if you look at this is an article about The Hill talking about Huma Abedin's Muslim Brotherhood, infiltration, not invasion, for future events. Muslim Brotherhood has infiltrated our government. It's called Barack Obama article. Muslim Brotherhood remarks, listen carefully regarding no arrest justice yet. What if almost every critical position senior within the U.S. government apparatus was infiltrated? What must be done first? The swamp runs deep, plus sleepers. Now, the AG of Minnesota is of this group, changed his name, Ellison. Backgrounds are important. Muslim Brotherhood. List of in the news now names. Who is known ties to Islam? This is not another 4-year election. Assumptions correct. Package well received. Known. Shahidi.
Yep.
Okay. Huma, Muslim Brotherhood. You got Awan. You've got the guy down here in Parkland. Says he's Jewish. Supports the Muslim Brotherhood. I mean, you know,
supports organizations and gatherings of MB.
Here's full circle. Muslim Brotherhood, the Brotherhood. It's all connected. Welcome back, Huma. Now comes the pain. Look at Nancy. Look at John Kerry. Is the picture being painted, folks? So here's another one. The Hill, pundits presidential campaign. Huma Abedin ties to the Muslim Brotherhood. Good article. Don't forget about Huma. Awan, Valerie Jarrett. FBI, America for Sale, Betrayal, Treason, No Name, Inside Out, Destruction, SA, Huma and Hussein. Harvard alumni, HUMA. Harvard University Muslim Association. Who paid? SA, Vital. Who are the Muslim Brotherhood? You know, traveling around, you know, the world, trying to say that, hey, we're going to impeach them. You see this. Why is this relevant? Who has ties to the Muslim Brotherhood? Who's Awan? I mean, look at what you've got here. I just put a search in and look up Brotherhood. Now, let's put a search in and put ISLAM. Now, I have nothing against Muslim people, right? Because a lot of Muslim people have good intentions. There's a radicalized sect of these people that are governing us, trying to govern us. This is Ilhan Omar. Interview, fearful of white men and Islam. And she's in our government, folks. Elected government, guys. This is what they're afraid of, guys.
She just happens to be from the district that was the powder keg or all this.
Yeah, that was her district in Minneapolis, folks.
Correct.
As a key member of the squad, speaking about the president a moment ago, at a conference organized by the Muslim Collective for Equitable Democracy. We have the clip, and here it is.
Now, even when we're talking about the president, people will say, you know, his remarks are racist, and will forget the inherent racism that has always been part of him, and how much he always takes an opportunity to others to vilify them.
Mark Merritt has been listening as well. He's live in Washington. Let's begin with you, Mark. Brand new hour. Good morning.
And good morning to you, Bill. Representative Omar on the stage here where we are at the Muslim Caucus of America event. It's a meeting where she's been able to speak for the last 20 minutes or so. She's there on a panel discussion, and as you just played in that clip right there, she was speaking about her thoughts on this latest back and forth between her and President Trump. She is still on stage at this moment. When she addressed the comments when she took the stage, she talked about President Trump, and she believes his past views that believed, in her opinion, that he is a racist. She talked about his past stance on the Central Park Five. That was the case from the late 1980s, early 90s, about the 5 men that were incarcerated, about that she feels that this is a change from a number in 2020 because of America hating anti-Semite Representative Omar and the fact that Minnesota is having its best economic year ever. I will win the state. He also goes on to talk about Congresswoman Alexandria Ocasio-Cortez and the three others that have been known as the Squad, this latest back and forth that has engulfed both the White House and these members of Congress.
So there you have it. And then we go back to that clip that we just saw about this. Let's watch this real quick.
Fixed our broken school systems. We have failed America's children.
This gentleman here,
Dr. Cornel West,
he won't answer is Islam.
He just gave me old talking point. I'll speak to you, Dr. Cornel West, black man to black man. There's looting going on, and you try to conflate. No, it's my turn. It's my turn. You try to conflate protesting and.
Yep.
You try to conflate protesting.
Whose side are you on? Who's paying you? He's saying.
They fixed our broken school systems. We have failed America's children.
You know, Sean, you asked Dr. Cornel West the type of question you asked in the court of law. He won't answer them because he just gave me old talking point. I'll speak to you, Dr. Cornel West, black man to black man. There's looting going on, and you try to conflate. No, it's my turn. It's my turn. You try to conflate protesting and.
Wow, they don't want this video played, guys.
You refuse to address the issue because I'm talking to you. You're not my brother. You're not.
See, he knows what brother means.
You are hurting black people.
Brotherhood.
You are taking the wrong position. No, my brother. That stuff plays out. That plays out. Address your question. Do you? Oh my gosh, you have.
Wow, they hate this video, don't they? Thought I'd just kind of show you that. Then you can basically look at anybody else. Let's look at Antifa ties to the Muslim Brotherhood. You think there's anything there? Oh, look. There are decades where nothing happens.
The Attorney General in Minneapolis.
Yes, Ellison. So you got that. Let's see what else we got. You think Oprah? Think she has anything to do with Islam? Wow, she liked. She had a whole show about Islam, guys. Nate Cain, sleepers. Remember the Nate Cain? We were talking about Nate Cain the other day. And you know why we're covering this is because this is what's happening, guys. This is what's happening, and I just wanted to just cover that real quick. Shady, you got this one here.
Yeah, we could show them this so that they can understand just a little bit. We'll scroll down on this just a portion. No, not necessarily the video.
Well, it's unavailable.
There's some information. Yeah, the video doesn't work.
Okay.
But this is talking about the secret society, the Boule, the Black Boule Society. Now, what is that? Rich, elite, homosexual secret society? Now let's scroll down here and take a look a little bit further, and let's do just a second or two of reading. Talking about the what could the Boule offer America's blacks in the early 20th century? Joining the exclusive secret society offered advancement and perks to select blacks in return for loyalty to its objectives. The upper tenth of the blacks started to live the good life as Boule members, while the majority, ordinary, were disenfranchised. But what were Boule's objectives? To recruit the top blacks to American society into its ranks. 5,000 archons, male Boule members that are wives, archoists, 112 chapters make up the wealthiest group of black men and women on the planet. Archon means demon, the kind that like to keep hidden. But to who does the Boule really serve? The satanic, mostly white global elite, as long as the black members perform.
Where'd that come from? Oh, my video started playing again.
Where are we at?
Hang on.
Now it's playing.
It's playing now, guys. My brother?
My friend,
Let's see,
no,
where is
I don't
he?
think so. Because your position is
Wow,
so
Shady.
way
I can't
off.
find it.
I will not respect
You come on the block disrespecting people. You disrespect me the day that Brother Floyd is black.
There's all my Twitter links. I can't find it, Shades. There it is.
That does not work on me. You're wrong, my brother. Keep saying that. It's all talking points. All talking points.
Hang on, guys. Leo, give me a second. Guys, everybody's mic'd out. Hang on. Guys, one at a time. Cornel West, then we'll go to Leo. Cornel, you're up. Now when Floyd Jr. put in the grave, no.
Leo?
Okay, I'll wait. Okay, thank you. Can I just, you know what? You asked him a very simple question. He won't say he's against defunding the police because you know what? He's in favor of defunding the police. I'm opposed to it. And this man is a dinosaur. We have to protect.
All right, so they don't really want you seeing that video, guys. All right, Shady, back to this. So this is interesting, huh?
Yeah, I just wanted to show everybody a little bit of, so you can see who the Al Sharptons of the world and the Oprahs of the world really are.
And possibly, like, you know, everybody else, the Jay-Z's, you know, here's the Delta.
That's the same thing, right? They're all members of this. And remember how Q told us that how do they get people to these positions? They elevate the people who take.
You know, they start the Prince Hall Masons, and then they get them from there. Just like any Mason, there's often different tracks of Masonry that you can take. Very interesting, Shady.
A lot of people don't understand how much this secret society stuff is prevalent. Even, you know, every single university, they all have fraternities and orders and societies. Those things are not in conjunction with a republic.
Wow.
They're more in conjunction with ancient Greece.
Yeah, absolutely. That's a very interesting article, guys. I'm going to drop that in there for you.
Which was a democracy, by the way, a mob rule democracy.
That's right. There's the link that we're looking at right here, guys. So that's interesting, guys. I just wanted to kind of show you a little bit of that. Shady, good conversation we watched today. We listened in to the Flynn hearing. We looked at Q posts with Muslim Brotherhood. Here's the one that is, Islam, the power of Anon research. List of in the news names ties to Islam, right? So now we're looking at just Islam. Council of the International Islamic Council for Dawah and Relief. So this is the Clinton campaign. Again, Abedin, Huma, they brought her in. Family ties to Muslim Brotherhood and to Saudi Arabia. Saudi Arabia kicked them out. Jordan kicked them out. This is what's happening, guys. Shady.
It's very relevant to hear what the general said in the clip that we were playing a little bit ago. We cannot successfully fight off the enemy if we cannot agree on what and who the enemy are.
And, you know, what has Q been saying, Shady? Invisible enemy, right?
The invisible enemy. What's your president been saying? The hidden scourge?
And infiltration, not invasion. Muslim Brotherhood article right here, 5/19/2020. Infiltration, not invasion.
He who looks for the hidden hand.
Wow, Shady.
There's a reason they hide the hand. The reason that they hide the hand is because it's a symbolism that you do not know what they're doing.
That's right. That's right. Wow, guys.
They're hiding the hands they toil with.
That's right.
Symbolism is very
The very
smart.
word secrecy is repugnant in a free and open society. And we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify it. Even today, there is little value in opposing the threat of a closed society by imitating its arbitrary restrictions. Even today, there is little value in ensuring the survival of our nation if our traditions do not survive with it. And there is very grave danger that an announced need for increased security will be seized upon by those anxious to expand its meaning to the very limits of official censorship and concealment. That I do not intend to permit to the extent that it's in my control. And no official of my administration, whether his rank is high or low, civilian or military, should interpret my words here tonight as an excuse to censor the news, to stifle dissent, to cover up our mistakes, or to withhold from the press and the public the facts they deserve to know. For we are opposed around the world by a monolithic and ruthless conspiracy that relies primarily on covert means for expanding its sphere of influence, on infiltration instead of invasion, on subversion instead of elections, on intimidation instead of free choice, on guerrillas by night instead of armies by day. It is a system which has conscripted vast human and material resources into the building of a tightly knit, highly efficient machine that combines military, diplomatic, intelligence, economic, scientific, and political operations. Its preparations are concealed, not published. Its mistakes are buried, not headlined.
Sound familiar, huh, guys?
Its dissenters are silenced, not praised. No expenditure is questioned, no rumor is printed, no secret is revealed. No president should fear public scrutiny of his program, for from that scrutiny comes understanding, and from that understanding comes support or opposition, and both are necessary. I am not asking your newspapers to support an administration, but I am asking your help in the tremendous task of informing and alerting the American people. For I have complete confidence in the response and dedication of our citizens whenever they are fully informed. I not only could not stifle controversy among your readers, I welcome it. This administration intends to be candid about its errors. For as a wise man once said, an error doesn't become a mistake until you refuse to correct it. We intend to accept full responsibility for our errors, and we expect you to point them out when we miss them. Without debate, without criticism, no administration and no country can succeed, and no republic can survive. That is why the Athenian lawmaker Solon decreed it a crime for any citizen to shrink from controversy. And that is why our press was protected by the First Amendment, the only business in America specifically protected by the Constitution, not primarily to amuse and entertain, not to emphasize the trivial and the sentimental, not to simply give the public what it wants, but to inform, to arouse, to reflect, to state our dangers and our opportunities, to indicate our crises and our choices, to lead, mold, educate, and sometimes even anger.
Wow. What do you think of that?
Some timeless words there, huh?
Yeah. And they mean even more now, don't they, guys?
Yeah, because it's like right up front. Back then, no one really understood what was going on. Like he was doing that speech, but a majority of the people listening to him really didn't understand what he was talking about.
Yeah, they didn't at that time.
Because he was exposing them. This was part of the run-up to why they had to target him and why George H.W. was put in charge of making sure he shut up.
Yeah. And they don't like General Flynn. They didn't like putting Iran on notice. I mean, you got to see what's happening here. I mean, they sent, how much money over to Iran that's probably being used against us today, guys?
They're using it to fill their Democrat donation coffers.
That's right. Whoop, there's a commercial. Sorry, guys.
I got a commercial.
Skip this ad.
Recent Iranian actions involving a provocative ballistic missile launch and an attack against a Saudi naval vessel conducted by Iran-supported Houthi militants underscore what should have been clear to the international community all along about Iran's destabilizing behavior across the entire Middle East. The recent ballistic missile launch is also in defiance of UN Security Council Resolution 2231, which calls upon Iran not to undertake any activity related to ballistic missiles designed to be capable of delivering nuclear weapons, including launches using such ballistic missile technology. These are just the latest of a series of incidents in the past 6 months in which Houthi forces that Iran has trained and armed have struck Emirati and Saudi vessels and threatened United States and allied vessels transiting the Red Sea. In these and other similar activities, Iran continues to threaten U.S. friends and allies in the region. The Obama administration failed to respond adequately to Tehran's malign actions, including weapons transfers, support for terrorism, and other violations of international norms. The Trump administration condemns such actions by Iran that undermine security, prosperity, and stability throughout and beyond the Middle East, and which places American lives at risk. President Trump has severely criticized the various agreements reached between Iran and the Obama administration, as well as the United Nations, as being weak and ineffective. Instead of being thankful to the United States in these agreements, Iran is now feeling emboldened. As of today, we are officially putting Iran on notice. Thank you.
So they didn't like that, Shady.
Checking out our YouTube.
They didn't like that. That is why he is in the issue he's in right now. Remember, Crossfire. It's a Flynn document dump. Remember that? It was Crossfire Typhoon in regards to General Flynn, Shady.
Yes.
And there it is right there. Crossfire Razor, Crossfire Typhoon. These are Q posts, guys. We know everything that's happening. We have it all. So this is it.
What was Hillary Clinton's case called? What they called, like a day at summer camp or something?
Yeah, and that's what they're calling. It's up over there in Seattle right now, where you are leaving the United States, going into this zone, whatever you want to call it. Does that mean that we can bring in our U.S. military, Shady?
Well, I think, it's kind of interesting because they created a border.
That's right.
So they went inside the city limits and they created a border, but they stand for no borders.
Right. And they build a wall.
So, yeah, they built a wall, and they don't think that a country should have borders, but they built a border and declared a country.
And absolutely. And Q says, when this is finished, a much bigger graphic will be needed. Much bigger. Biggest political scandal in American history, folks. It's an American coup d'etat. And there you have some of them. And you can tie the Muslim Brotherhood to each and every one of these people right here, and radical Islamicism. Every single one of them
took. And that's why they put all this cash in Iran, was so all these people would be enriched.
That's right. Wow.
Very simple.
I think the picture is being painted pretty clearly. Press 17 if you guys understand. If you guys know a Democrat, maybe just say, hey, you're allowed to be a Democrat. Let's not make fun of them anymore. People that were Democrats in the John F. Kennedy years are not these Democrats today. They left your party. They really did. And it's sad. Because people that I know, if they knew that their Democrats are supporting radical Islamicism, they would be, their mouth would hit the floor. That's why this election, whether you like Donald J. Trump or not, it's about clean elections. It's about the future. Because if there is an honest Democrat out there, I'm with it. There's no honesty anymore. Even in the old guard Republican Party, we need to make sure that our elections are clear and the news and the information is free, like on the news. And that's what we could all sit down at a table and agree with that. I guarantee.
And it's exactly like all this other stuff. If anyone understood what was really going on with the human trafficking and with the sale of people and the selling of organs and all of this craziness with Planned Parenthood, if 95% of Democrats understood that 11 states were having abortions at 9 months and understood what they were doing with this material, they would be against it. But no one has the information, much like the Democrats and all of this stuff before. Yeah. They don't have the information. We're trying to get them the information, and information warfare means as we give information, they attack us as conspiracy theorists. Remember, they've been calling things conspiracies since the Middle Ages. You guys do remember the church and what they were doing to astrologers and scientists and stuff in the Middle Ages, right?
Yeah.
Okay, this is the same exact thing. Mob rule.
Mob rule, guys. And that is the mob.
That's the mob.
Wow. I think this has been a great show today. I know we went on a little early because we wanted to cover this. There was like 30,000 or more on the live feed, another 1,000 or more here. But I think we probably had more than that, Shady. What's going on tonight, Mr. Shady?
Tonight, 9 p.m. East, 6 p.m. West. Q Lounge Live, guys. Please come over and join me. I've got a pretty strong rant in store for you this evening.
So we've got a Q Lounge Live tonight, guys. Do you understand how excited I am right now? Thank you very much, Shady. And with that, let's go out with a General Flynn tribute, and it's called Digital Soldiers by JT
If you manage a
Wild.
team, you should be using Monday.com.
It's
First, a message from our non-sponsor.
Here we go. God bless General Flynn. Prayers up. Thank you, Sidney Powell. Shady,
This
see you
was
tonight.
irregular warfare at its finest. We have an army of digital soldiers.
And blood, praying for an answer to the Lord up above. How can just one man be the shelter from the storm, knowing that the real war has only just begun? The storm is getting closer. We are the digital soldiers. It's time they run for cover. We are the digital soldiers. Will be redeemed. The sacrifice they make won't be in vain. The fight for freedom is all that remains. We're gonna tell the people's story and make it right again. The storm is getting closer. We are the digital soldiers. The needless wars are over. We are the digital soldiers. We will bring the light to this field of fight. We have been blinded by the lies. We've been living to survive. They will steal and make you pay. When will we walk away? They want you dead before your time. They want you watching while you die. Just live to fight another day. It's time to walk away. The storm is getting closer. We are the digital soldiers. Needless wars are over. We are the digital soldiers. The storm is getting closer. We are the digital soldiers. We are the digital soldiers. We are the digital soldiers. We will bring the fight. Digital soldiers. Yes, we will bring the light to this field of fight. We are the digital soldiers.
You are. We are the Digital Soldiers. JT Wild. Let's see him get in his car. There he is. Thank you, JT Wild.
If
much
you're serious
love.
about your
And I'm not
business, you
serious.
need to-
Well, I should be serious. We're serious. Well, guys, thank you very much for coming. We appreciate you all. We want to just make sure that you know that we need you now more than ever. We covered the Flynn case today. If you can, join our Patreon. The mods will drop the link. It's patreon.com/intheMatrixxx with 3 X's. $10 gets you in our Q Army Plus server where there's a bunch of amazing people, and they're here today. That'll support us and help us, and we can come and interact with you guys. PayPal as well. Links down below in the description. And by the way, can you hear me? Much love, everybody. Q Lounge Live tonight, 9 p.m. East. I hear you. Let's get loud, Patriots. Prayers for General Flynn. God.